Then we should lock it. Let them both these two items may kindly taken away the first item lock if they are present.
So I beg to mention item number 37, my lords. As I appear for the petitioners, my lords, the state government has preferred a writ appeal against the order in question, my lords. My lords,
Item number
37, my lords. There is a writ appeal pending, my lords.
okay.
My lords may take it up after 4 weeks, my lords.
Your good name, please.
Beach Chaudhary, my lords.
On request made by B. Chaudhary, on
I'm deeply
after 4 weeks.
4 weeks.
This matter may be listed next week, my lord. On 29.
That's why I'm praying for listing of this matter on next week, Lordship, 29th, Lordship.
May it please refer your lordship. Lordship, for item number 33, lordship, we have filed our additional affidavit. We may be allowed to bring it on record, lordship. Obliged, lordship.
What's been item number 52 similar pair for bringing on record the reply that we have filed today, lordship. Item number 52 of the supplementary list. No, obliged.
Lordship, in regard to item number 8, I'm seeking for some indulgence from your lordship. Can the matter be taken up at 2, lordship? Item 8 at 2, lordship.
Why at 2?
Lordship, the file is to come from the office. We could not trace. That's why. But it's.
You already standing counsel?
I'm the petitioner,
Petitioner.
counsel for the petitioner, lordship.
So you've forgotten your file.
No, lordship, we could not trace it from the office. We will be bringing it within 1 to 2 hours, lordship. Only deeply obliged.
Lordship, we beg to mention item number 41 and 42, Lordship. Conducting senior counsel is out of station, Lordship. Matter may be possible for the
Who's
day.
the senior counsel?
Mr. DP Chaliha.
Request made on behalf of the DP Chalia, let the standing counsel. Let the senior counsel for the petition. When? Please, after
November, Lordship. November ended.
2 weeks.
Please.
May I please, lordship, pair for listing, lordship, metal listing, lordship, salary, lordship, on Monday, lordship.
Okay.
Same pair, lordship. Another one.
Hmm?
Same pair, another one, lordship. Two, I have to mention, lordship. Same pair.
What a salary method?
Yes, lordship. Yes.
May it please your Lordship. Lordship, I beg to mention for listing a writ petition for Friday, Lordship. Suspension matter, Lordship. Termination matter, Lordship. Friday,
The motion matter?
Lordship, motion matter. Friday, Lordship.
When was the suspension order issued?
Lordship, in the first part of 2024, Lordship. He has approached the concerned authorities 2 times, Lordship, but nothing has been done, Lordship.
There's no urgency with that. We'll have it on Monday.
Lordship. Oblige your Lordship.
My lord, I like to mention lordship item number 44, 46, and 47. Or our state review, lordship. All the B Kosik and Anjekana, they had some difficulty today, lordship. May can take it up next week. All the 3 items, lordship. 44, 46, and 47.
Okay, 44 on request made on behalf of Mr. P. Counsel. The standing counsel second case department. List after 1 week. Item 56
And 47 after 4th of October, lordship.
On request made on behalf of Interim. Standing counsel,
He is elementary, lordship.
elementary part. Is the matter
On 5th or 6th, lordship, we can
on 6.
oblige you.
Separate,
Yeah, please, your lordship.
separate order.
I beg to mention item number 38, your lordship. 38.
Yes.
Yes, I beg to adjourn the matter for today, your lordship. The senior counsel is he has a medical issue, so he couldn't be present to this honorable court today.
Senior,
Yes, that's your lordship.
have you informed the other side?
Yes, sir.
Okay, on request made on behalf of S. Das. Learn the copy for the petition. When do you want
Any date is fine, your lordship.
the matter after 1 week?
Yes, lord lordship. Much obliged.
May I please, my lord. My lord, I beg to mention a contempt case, my lord, non-payment of arrears salary. May it be listed on 25th, lordship. Obliged.
May I please, Lordship, but I beg to mention for listing, my Lord, the matter pertains to transfer of posting, my Lord, which is a physically disabled person, my Lord. My Lord, the matter listed on February, in the month of February. My Lord, maybe listed next week or first week of November, my Lord. Any day.
Okay, 6.
Obliged, my Lord.
May I please your lordship, prayer for listing a contempt matter, lordship, 128, lordship.
Eight.
Eight. Lordship, can it be? Lordship,
May I please your lordship? Lordship, I beg to mention for orders. Listing of a matter for orders which was last posted on 28th August 2024. Okay. Yeah, 8 November. Oblige, lordship.
May I please your lordship? Lordship, I beg to mention for listing of writ petition for orders, lordship.
6.
Blessed lordship.
May it please your lordship. Your lordship, I beg to mention for listing of a matter, your lordship, that is WPC 2789 of 2024. The matter will be listed in the admission column, your lordship. Any date convenient in the month of November, your lordship.
11.
Deeply obliged, your lordship.
Item 3 and 6 of daily motion.
These are connected matters?
No, so all two are separate measures.
Separate.
Lordship, can take the 3 first.
Yeah.
I think this is the instruction that we have. Hey, to did it. Basically, Lordship, in this case.
1 minute, 1 minute. Yes.
Yes, basically, Lordship, personal defense was issued because we are unable to provide the instruction in time, Lordship. In fact, it was not a fault of the contempt, it was fault on the standing counsel. We couldn't intimate the authority in time. Anyway, Lordship, we have received the instruction. Lordship,
What
kindly,
took you so long to get the instruction?
that is the fault on our part, Lordship, that we have
Why?
to admit. That is the
What,
part.
what did you do?
Let the earlier council, Lordship, I think they have failed to communicate properly in time. Ultimately, it was Lordship intimated and inquiry was held in. Lordship, kindly turn the flag mark, Lordship. There's the fraudulent part.
4 times you were given.
Yes,
time.
yes, Lordship.
4 times.
Yes. 3 times, Lordship. On 4th occasion, Andrew Cardinal appeared and he said that.
On 27/5/2024.
Yes.
12/6/2024.
Yes,
26/6/2024.
yes, Lordship. Yes. 3 times. In earlier 3 occasions, though our separate councils appeared, they failed to Lordship. That I admit, and I apologize for that. This fault on our part, not on the fault on the part of the commission and the director, Lordship. Anyway, Lordship, that this happened. And ultimately, when this personal defense was issued, Lordships were, concerned authorities were intimated, and Lordship may kindly see the findings, Lordship, that mark Lordship I have given. And inquiries were conducted by the director, Lordship, later dated 15 October 2024. And the findings, Lordship may kindly peruse, Lordships. It appears that the petitioner Habibur Rahman, head teacher of so-and-so school, has rendered his service from 1/3/2023 up to 28/2/2024 by way of manipulating the date of birth as 2/2/1967 instead of 1/2/1963. Lordship, after he has extended his service after Lordship for 1 more year, Lordship, from the date of his retirement, actual retirement date, Lordship, by manipulating these record, Lordship. It is fault on the part of the petitioner, Lordship. That is by.
That's fine, that's
Yes.
fine. That's where you file your affidavit.
Yes,
There's nothing.
yet I will file it, Lordship.
The only issue is why we called the director and the secretary.
Because we couldn't file our
Why you did not bring your report?
records in time. That is on the fault on our part, Lordship.
Who's the secretary?
Secretary There is 9 and director lordship.
When did you receive the communication from the standing council?
After last document. After last order, lordship said order dated
310.
3/10/2024. And then and the Khatana, he has informed the secretary and director which copy of the writ petition.
So what were you doing for
That is the
past 3 of
that is the fault on our part, lordship. I have and I apologize for on behalf of my colleague, lordship. Normally that does not happen, lordship. In this case, lordship, it has happened, lordship. Normally we used to take the instruction in time in most of the cases, lordship. Sometimes it is low. But here we are going to find an
the
affidavit.
deputy inspector of schools is present
DO. Middle court.
and the DO.
DO, lordship. All are present, lordship. Now we are initiating lawsuit or criminal as well department proceeding against the petitioner lawsuit.
Yes,
Lordship, in Annex 3, page 22, it is given his date of birth as 1/2/1963,
Hmm.
which is an extract of the service book of the petitioner.
yes. Have you seen the report?
No,
No.
we have to file an affidavit on lawsuit. We are filing a detailed affidavit in this regard, lawsuit.
Okay. What MS J. Rashtamari, Learned Council. The Secretary to the Governor of Assam, Education Department, the Director of Elementary Education, the Deputy Inspector of Schools, Nago, and the Block Elementary Education Officer, Bhatia Tuli, Nago, are personally present in court, pursuant to the directions passed by the court on 3/10. Para. It is the submission of the consent of who are present in court today that they did not receive any communication from the standing council prior to 3/10/2024, and that only on receipt of the order dated 3/10/2024, the the director of elementary education Assam had conducted an inquiry and the said inquiry report was submitted to the secretary to the government of Department of School Education on 15th October 2020. Para.
And first with it is
Mr. SMT Kishti, Learned Standing Council.
Elementary.
Elementary Education Department submits that it was the fault of the Learned Standing.
Yes.
Elementary Education, Elementary Education Department in not communicating the orders passed by this court on earlier and tenders his apology for and tenders his unconditional apology for doing this. He however submits that as the report of the Director of Elementary Education
As well as on the secretary lawsuit.
as well as
The first page.
has already been submitted to the Secretary to the Government of Assam on 15/2024. He submits that he may be the Department of School Education to file accept. Or recording the submissions made by the constant office presently for, as well as the Leonard Standing Council, Elementary Education Department. The apology tender for this court is settled. Notice has gone? No.
No.
Issue no.
Formal.
Mr. SMD Chishti, Leonard Standing Council, Elementary Education Department. Appears on behalf of the respondents 1, 2, 3, 4, and 5. Pension,
Pension government.
Mr. B. Theory, Leonard Governor. Appears on behalf of the respondent. Notice and respondents are complete. However, extra copies of the furnished to the letter on separate. Respondents are allowed to file. Please, the matter after
2 weeks.
2 weeks.
Lordship, an IA has been filed. So the
Where's the
party may.
IA? Where is the IA?
I is not along. It probably it is not shown in. Tag 1 and police has spoken it.
It is not reflected.
Not reflected in police.
When did you file your IA?
In September.
Oh yes, I is.
Oh,
Yes, I is there, Lordship. 314524. Yes.
Okay. The personal appeal of the secretary to the government of some school education department, director of elementary education, the deputy inspector of school, Nagaon, and the block elementary education officer, Patia to the former Nagaon, are different for the time. Yes, what is doing the IA?
It's an implement,
Whom do you want
implementing
to
of
plead?
for the block elementary Pathyapalli, which was earlier missed by me.
Block elementary education, Nagaon is written in the respondent number 5, Lordship.
Is there block elementary? No.
Only Kothatoli, that word is not there.
Pathyapalli.
So it will not be a case of implement, it will be a correction of the respond number 5, isn't it? Correction of address.
Yes. In the
Correction of address of the respond number 5.
Kothatoli be available. Yes.
So you file a
Lordship,
petition,
BO Nagaon, BO Nagaon. BO Nagaon, that BO Kothatoli is a different Lordship, so that will have to be implemented.
that will have to be,
That will have to be implemented.
okay. In the IA, third MS, J. Rajkumari, Learning Council for the applicant. Also heard Mr. SMD Chief, Learning Council, Elementary Education Department for the opposite parties 1, 2, 3, 4, and 5. And Mr. B. Deori, Learning Governor, opposite party number 6. The applicant, who is the petitioner, in WBC number 2716 of 2024, is praying for improvement of the block elementary education officer, as party with phone number 10 in the second. For the learning council, appearing for the opposite party of this court has also produced the court in the present application. Stop. According the prayer for petition is allowed. I is disposed. The applicant is directed to file an amended court title in the WBC number 2716 of 2024 within a period of 1 week.
Pleading petition file কৰিব লাগিব। কৈ দিব।
No. Then there will be some problem. So cancel that line. And in the main order. Say, on top, you say in view of the order passed, so, let the block element page which not. Be implemented as part of response number 7 in the president. After that, petitioner is directed to file an amended court title within a period of 1 week. After that, you say heard so and so, then continue.
But if interim order may be continued.
Interim order facility to continue till. Yes, item 6.
Yes.
May I please, Your Lordship. Lordship, may kindly peruse the order dated 310.
Get back. Annex to the. Who to annex to full annex to the. To report to the. Report to our copy as anyway.
That is the essence of the median.
Hey, every copy, someone given or every time I'm a.
Yes,
Yes, lordship here, lordship can turn to para 4 of the order dated 3/10/2024 lordship. This honorable court observed that from 1 to 2003, the petitioner remained absent in his duty in the said school. Up to lordship February 2026. Because lordship, in fact, lordship can turn to page 23 annexure 6. This finding was observed by this honorable court on the basis of a wrong lordship's report given by the DO Gulahat lordship. It was page 23. 12th line lordship. From 1 line number 12 lordship.
Page 23.
Page 23 annexure 6 in the writ petition. In the writ petition number lordship 3906/2024.
Additional affidavit.
Huh?
Additional-
I don't have page 23.
No, in additional affidavit lordship.
No, no, it written হয় জানো? It written it. It written হয় জানো?
Even additional to আছে.
It written item it yes answer 26 23 written নাই জানো 26 or page আছে নাই?
Yes.
Even the same lordship will find in page number 27 of the.
In my writ petition served by the petitioner lordship, the annexer is at annexer 6 page 23 and they have also annexed it in their additional affidavit lordship may kindly peruse. Additional affidavit filed on 6/9/2024. Here annexer 7.
Yes.
In the 12th line lordship may kindly peruse. The deputy inspector deputy
Which line?
in the line 1 2 3 in the first para lordship para number 1 10 line number 10 lordship. The deputy inspector of schools informed the undersigned that Dilip Kumar Sharma, assistant teacher of Puramuk ME school, has been found absent in his duty with effect from 1/2/2003. This was wrongly lordship inserted in this report lordship. Actually, lordship may kindly peruse the findings of the director. I have submitted that now lordship. Here lordship, that director after lordship making an inquiry, it was found that the petitioner Dilip Kumar Sharma was performing his duties as assistant teacher of Puramuk ME school, Gulaghat till 28/2/2006. And accordingly, he rightfully received his salary for the period with effect from 1/1/2003 to 28/2/2006. Because of the wrong insertion lordship, which Honorable Court thought that he was lordship received his salary lordship without working.
Who is the district elementary education
It
officer?
is earlier lordship, not the present one lordship. It was issued on 9/9/2023. He has already been transferred lordship.
Yeah, what steps have you taken
Lordship has
against him? for
and now
making such a-
now the
making such
yes
a
yes
wrong report?
secretary is going to take a disciplinary proceeding against those heading
Now,
officers.
When are we going to initiate disciplinary
We
procedure?
have just received a report from director, so by district will.
By district lordship, you will receive the DP lordship, the proceeding lordship. In the earlier case also, here also lordship, both the cases, for all the hearing officers. Because the assumption that court made that he was wrongfully gained the salary, that is lordship, it is not wrong, not right. No.
Then the other instruction.
Now lordship, thereafter he has remained unauthorizedly absent lordship with effect from 1/3/2006 till his suspension on 16/9/2006 lordship. Now lordship, what happened, he is retired. Now what we have learned from that, he is under judicial custody in a POCSO case lordship. So because for his pensionary benefit, he had to come and file his document that he is unable to file his lordship. That's why we are unable to proceed also. We have issued notice also lordship. And even in departmental proceeding initiated against him lordship, he didn't cooperate. Now he is under judicial custody lordship.
No departmental,
Huh?
no departmental proceeding was initiated lordship. This is wrong submission lordship. by- by-
There's
by
no
that.
departmental proceeding against the petitioner. Now the
I was put-
secretary is saying that he's going to,
Yes,
he's
yes.
going to initiate within the period of 1 week.
Yes.
Then how do you say there's a departmental proceeding against?
No, long earlier lordship notices were issued. When he was suspended on 16/9 on lordship
16/9.
16/9/26.
Where's the suspension order?
Lordship, you will find it page 14 of my petition. And I was kept under suspension for 8 long years, Lordship, without any review was made. No substitute allowance was also given.
Till date, you have not been paid your.
No substitute allowance, nothing, Lordship. 8 long years I was put under suspension and no review was made, Lordship.
Lordship, may kindly peruse our report of the director, lordship, para 3. To finalize the departmental proceeding against the petitioner, Deepak Kumar Sharma, a so-called notice was issued to him by the then DO Gulaghat on 6/3/2000. Eto cut khai golo na meeting. Even 2 FIRs were also lost by the DO Gulaghat.
Mr. Chishti, when the show cause notice was issued on 6/3/2007,
Yes, sir.
how many days was the petitioner given to make his reply?
10 days was given, Lordship.
10 days was given.
Yes.
You did not take any action. You waited for 1 full year.
Yes, then second, no,
After that, what did you do? Nothing. It's your fault.
yes. Now, he was missing at that time, Lordship. He was not traceable, Lordship. And he was not cooperating with the authority also. And that's why FIR was also lost, Lordship.
Second show cause notice was issued on 25/3/2008.
Even we have published in the newspaper also, Lordship.
That is a different thing.
Yes.
First show cause was 6/3/2007.
Yes, your Lordship.
10 days time was given to make his reply.
Yeah, he didn't
He
reply.
did not make his reply. What did you do after that? You waited. You waited for 1 full year.
Yes, yes.
Then only after that you made your
Second notice was
second
issued
notice on
after a year. Yes,
2008.
yes.
So who's responsible for this?
We have, again, it is the duty of the petitioner also to cooperate, to come and cooperate with
That is
the.
fine. Petitioner
He should
never
have come.
cooperated.
Yes,
Petitioner
because
did
he
not.
went missing, there
So
FIR
what
was
did he
filed.
do when the petitioner did not cooperate?
Yes.
And after expiry of 10 days, after
Yes.
the first show cause notice.
Yes, sir.
What did he do?
Yeah, apparently, nothing has been done.
Nothing happened.
Let-
You waited for 1
Yes.
full year.
Then second notice was issued.
Let him go scot free.
Thereafter, the FIR was filed with the DO Lordship. But his conduct is also not that fair, Lordship.
I'm not saying anything about the conduct of the
Yes.
petitioner at this stage.
Yes.
But what this court wants to know is,
But authority,
when the first show cause notice was given,
Yes.
10 days time was given for him.
Yes,
to
yes.
File his written
Yes. nothing has been. That's-
statement. He did not do. After that, what did you do? Nothing. 1 year you waited.
Then the second notice was issued.
Then-
Anyway, Lordship, now he is under, as soon as he is. Now the secretary said that we are finalizing his pension proposal also. Lordship only take, he is under judicial custody, so he has to come and submit his papers, Lordship. Then we will find that,
Lordship, there should be a direction from your lordship that to allow him to come and sign the.
he is under POSCO Act, Lordship. And
He is a 70 years
376,
old
Lordship.
lordship,
He is a 376 sec, under
In a
section
writ- in a writ
376.
proceeding,
lordship.
you'll have to approach the appropriate court.
Yes.
We have already approached. We have already approached lordship,
If no steps are taken, then you can come before this.
lordship.
By way of an appropriate application.
Yes, lordship,
But not through this direct, or not
Lordship.
direct.
Yes,
through
yes.
this-
lordship. Lordship.
But Mr. Arda, London Council. Para- The secretary to the governor of Assam. School Education Department. Comma. The director of elementary education Assam and the district elementary education officer Kolar are present in court. Pursuant to the order passed by the court on T10. Para. The secretary to the governor of Assam, Department of School Education, submits that the pension proposal in respect of the petitioner is under process. However, the petitioner has to submit certain documents for which his personal assessment is recorded,
He have to sign the pension proposal paper, Lordship.
and also sign the pension proposal.
Hmm.
However, it is, he submits that it is within his knowledge that the petitioner is present in judicial custody in connection with the.
One eye.
All right. The director of elementary education who's also personally present in court.
pencil paper to sign no?
Submit. That the petitioner was performing his duty as assistant teacher of Turamuk ME School, Kolkata, till 28 to 2006. And accordingly, he was rightly paid his salary for the period with effect from 1/1/2003 to 28 to 2006. Stop. However, this court, on the basis of the communication dated 4/4/2023, written by the District Elementary Education Officer Kolkata, wherein it is stated that the petition has been found to be absent in duty with effect from 1/2/2003 till February 2006. This court has this court has passed the order dated 3/10/2024. She however submit that it was the wrong entry made by the District Elementary Education Officer that has led to the issuance of the order dated 3/10. He submits that on the basis of inquiry, it was found that the petitioner was found serving till 28 to 2008. The secretary to the government of Assam School Education Department that appropriate procedure would be initiated against the District Elementary Education Officer Kolkata. The then District Elementary Education Kolkata within a period of 1 week, within a 1 period of 1 week. But notice has gone, no?
No.
Issue notice.
Regarding substitution allowance lordship,
Oh, so, no, they're processing the pensioner.
pension because but regarding substitution allowance.
Subsistence allowance.
For that, he'll have to apply lordship. Under
Substitution allowance is a right lordship. What application is for lordship?
There's no requirement
Yes.
for an application. You have to.
This is the property of the of an employee.
Mr. Assembly District Standing Council. Elementary
yes, sir.
education.
The FR 53 lordship for non-engagement lordship, he has to submit lordship. Fund is there.
Is on behalf of all the respondents. As such, no formal steps are required. However, it's the public. Respondents are allowed to file their. Let's the matter after 2 weeks. 3 weeks.
3 weeks.
It's the matter of 3 weeks. In the meantime, the respondents are directed to release the
Lordship,
allowance
yes.
to the petitioner. After all, following all laid down procedures.
Yes, your lord.
Lordship, one thing, Lordship. Lordship may kindly take the WPC number 4006 of 2024 along with this petition, Lordship.
Okay. WBC number
4006 of 2024.
4006 of 2020.
4. Deeply online.
এই দুটার এফিডেভিট লেখা সপ্তাহ ভিতৰত হা এটা না পাহৰিবা না না দুটা লেখা কাকো দিব নালাগে অবলাইজ ইয়ৰ লৰশিপ does a personal appearance discount
The personal appearance of 2021 are dispensed.
all the respondents in both the cases oblige you and duta leg below
Item 1 of daily leave.
Lordship, may kindly see the last order 89, 2024, my lord. They are supposed to bring, my lord, the updated instructions, my lord. The last 2-3 dates, my lord, same instructions have been, my lord, brought before the court. That is pending in the secretariat, my lord. It was sent, the proposal was sent to the, my lord, department.
Yeah, who appears Bukan?
This matter, my lord, we need 1 more week, my lord, time.
When he also personal appearance will have to report.
My lord, last time, my lord, we'll ensure that the instructions are brought.
I'm reporting, if no instructions are received by the next day, personal appearance.
2 weeks, my lord.
Heard Mr. M. Sharma and the counsel. Mr. F. Khan, understanding counsel elementary education, prays for 1 week time to enable his evidence.
My lord, will make it 10 days, 10 days.
Pays for 10 days time to receive instruction. Stop. It is seen from the various orders possible that sufficient time was given to the learned standing council elementary education. However, at the last and final, the prayers are. If no instruction is received by the next reasonable date, the personal appearance of the concerned officer shall be considered. List down, give a date of the 10 days.
8/11.
8 now.
My lord, during pendency of the state petition, the petitioner got the relief, my lord.
Then Shamal and counsel for the petitioner that during pendency of this petition, the petitioner has got his relief, and therefore the matter has become interesting.
IPF respondent kitchen
Elementary who appears, if standing counsel appears for the elementary education department. And Mr. B. Gogoi, learned standing counsel appears for the finance department. Correct?
Yes.
Which petition is accordingly disposed of as
Four.
No, please, your lordship. In this case, my lordship, instruction was sought for matter relating to discrepancy of 3 date of birth, my lordship. There are 3 date of birth certificate, my lordship, issued, my lordship. First one is 1973, next one is 1963, and one is 1370, my lordship.
yes.
Instruction was sought for, my lordship, from a long time. Instruction was sought.
Elementary.
4 dates gone, my lordship. Already.
Yes, Shama.
After some time, Lordship, I will.
Have you received instruction?
No, Lordship, not yet, Lordship. Lordship will fix after 1 week. Lordship. Instruction is awaited.
This is the 4th occasion, my lordship. They're taking time. There are discrepancy of 3
MS.
B bhoya, my lordship.
P. Boyan, Mr. B. N. Sharma, learned standing counsel, elementary education. Is 1 minute, is allowed another 1 week time.
Lordship.
Date may be
Enable
fixed, your
him to
lordship.
receive instruction, comma. If no,
Lordship, here we received parawise statement, Lordship. So we'll file our affidavit.
then we'll issue notice.
Lordship may issue notice, we'll file our affidavit. We have received it.
Heard MS.
B.
Boyan, learned counsel. Issue notice. Mr. B. N. Sharma, learned standing counsel,
Elementary, Lordship.
elementary education appears on behalf of respondents. 1, 3 and 4.
1, 3, and 4.
Additional Deputy Commissioner,
1-3 and
what? Mr. P. Cycle, let us governor affairs to respond. You are appearing for?
Private.
And MS,
MS.
M,
A Mason.
A Mason. Learned Counsel affairs for the respond number 5. Accordingly, not notice on respondents are complete. However, extra complete. Mr. P. N. Sharma, learned standing counsel, elementary department submits that he has received instructions and praise for 2 weeks time to file complaint. Praise, no? Please come to the-
Date may be fixed, your
It
lordship.
will come after 2 weeks.
Oblige, your lordship.
5.
Please, your lordship. Issue is that suspension order was not reviewed within 3 months. And in this regard, what affidavit has already been filed, it is admitted, my lord. Affidavit is on record. Last occasion, it was not on record.
You have to the affidavit.
Yes, we
My-
have filed our affidavit lordship. Filed by the secretary lordship. Departmental School Education.
Where is it?
Serial number is page number, it is again serial number, page number 1 is given lordship. The affidavit filed by the secretary to the Departmental School Education on 25th of September 2024.
Yes.
Lordship will find in page
Where's
number
the
3.
statement? Where's the
Well, paragraph 6, your lordship, kindly see. Page 56.
But before that, the lordship may kindly bear with paragraph number 5 also, lordship. The deponent begs to state that as per report received from the Director of Elementary Education Assam by letter number so and so dated so and so, Sri Hariprasad Das, Block Elementary Education Officer, Vishwanath District under suspension, was arrested on 6/10/2023 by the Director of Vigilance and Anti-Corruption Branch, Assam, in connection with so and so case number. It was also informed that one Sri Kiran Pegu, so and so, Majuli district, is an assistant teacher of Kambong, so and so school under Saiduar block. Vishwanath had lodged a complaint in the Directorate of Vigilance and Anti-Corruption, Assam, that Sri Hariprasad Das had demanded bribe of rupees 5,000 from the complainant for approval of to convert his temporary posting to permanent posting on 25/9/2023. On 6/10/2023, while complainant Sri Kiran Pegu went to the BO office and met the petitioner Sri Hariprasad Das, then the petitioner demanded bribe of rupees 7,000 for providing an additional teacher in the school of the complainant. For both the purposes, the petitioner Sri Hariprasad Das demanded total 12,000 rupees as bribed from the complainant, and on being requested by the complainant, Sri Hariprasad Das reduced the bribe amount to rupees 10,000. A trap team was constituted by the Director of Vigilance and Anti-Corruption Assam and accused Sri Hariprasad Das, Block Elementary Education Officer, Goapur, Vishwanath, Assam, was caught red-handed immediately after he accepted the part of the demanded bribe of rupees 3,000 from the complainant in a trap operation, and he was arrested in connection with ACBPS case number so and so so and so. Thereafter, the petitioner was placed under suspension by letter number so and so dated so and so. Accordingly, the departmental proceeding was drawn up against him, white Socus notice dated 11/12/2023. Socus notice has already been issued, and he had submitted Socus reply and written statement. Thereafter, the departmental proceeding is underway and hearing has taken place.
Yes.
So now become
Parasite.
para 6, that the deponent begs to state that the suspension order was reviewed by the suspension review committee held on 16/3/2024, and the order was issued under memo number so and so dated 8/6/2024. It is further stated by the deponent that the petitioner was allowed to draw subsistence allowance of at the rate of 50% for first 3 months, while later dated so and so with effect from the date of suspension, which was then enhanced to 75,000 with effect from 6/1/2024. While later dated so and so. Hence, the petition is devoid of any merit and is likely to be dismissed. That suspension order has been reviewed.
When was it reviewed?
On 8/6/2024. 8/6/2024.
It was not on 8/6/2024.
That the was reviewed by the
Taking a wrong-
held on 16/3/2000 and the order was
16/3/2024. When was the petitioner suspended? 14/10/2023.
14/10.
Was it reviewed within 3 months?
But in the meantime, Lordship, on 11/12, the so-called notice, department.
Notice was given. And then if you want to have a review, in terms of Ajit Chowdhury's case,
Lordship.
you have to file, you have to give a detailed order.
Otherwise, Lordship, he is getting substance.
I'm not on whether he's getting suspension allowed.
And now the department proceeding is underway.
Where's the extension order?
My lord,
The Lordship
Yes,
will find. Here on
page 56.
Where's your first suspension?
On 14/10/2023 with effect from 6/10.
Hmm.
That is at page 32 of my writ petition.
And your extension order?
It is not in their affidavit. It is page 60.
60.
60.
Yes.
Mine.
You'll have to file a reply to this. There's a detailed order.
But it was issued on 8/6/2024.
It was issued on 8/6.
Mine.
You were suspended on
14
14/10/2024 with effect from 6/10.
6/10.
Correct.
Mine.
After the disciplinary proceeding was initiated
Mine.
on 11/12.
That is correct.
That is within time.
That is
Within that.
Thereafter, they proceeded to extend the suspension order.
mine.
Now, when the suspension order was passed, extension order, they've given a detailed order.
That is correct, but it is not a why my continuation of suspension is required. That is not there.
Wait, look at the decision. Look at the decision.
And it is not
Page 60.
as per that Supreme Court order. It must be within 3 months.
Had the departmental proceeding not been initiated.
No. That is not there.
Let us see that.
That has been my lord, please. It is
But within the time we have, that department proceeding has been initiated.
initiated with
Para 21, is it?
para 21. That is my case. Otherwise, my lord, I have to face the proceeding. Para 21.
Read it.
Mine. We therefore direct that the currency of suspension order should not extend beyond the 3 months if within the periods the memorandum of charge sheet is not served on the delinquent office of it. If the memorandum of charge is served, that is within 3 months,
Yes.
a reason order must be passed for the extension of the term. That order must be passed and reason order should be passed. That was not passed within 3 months. That is after 3 months they have passed. That is
That's
the,
why I'm saying,
my lord.
you may have to file a reply. You have to file a reply, otherwise it will go uncontroverted.
That my law possibly it is clear that it is a record also that it is after 3 months. If Record
See,
says,
read it properly, read it properly.
my lord. If the memorandum of charge sheet is served, suppose within 3 months,
No. If within this period, memorandum of charge sheet is not served on the delinquent.
not served, then automatically it will go after 3
Okay.
months. After 3 months, it will
If
automatically
memorandum of charge is served.
is served. That is within 3 months.
order
If,
must be passed for extension of this.
yes, that extension order must be passed within 3 months. It is not that they after 6 months, they will pass the extension order. How it will be. That is my submission.
No.
And it is on
If
record.
memorandum of charge sheet is served, a reason order must be passed for the extension of the
Yes.
suspension order. But
Yes.
there is no, Lordship, the first line. Lordship, the first line. We therefore direct the currency of the suspension order should not extend beyond 3 months if within this period the memorandum of charges or charges is not served. So it has been served. Within the period of currency of 3 months, Lordship, 90 days, that memorandum of charges has been served. Departmental proceeding has been initiated.
We are not denying.
The first line itself,
Read it carefully, read it
yes.
properly,
My lord.
read it properly. Read it. Read it.
That is correct.
The question of interpretation.
Yes, yes, possibly. In this, all of Supreme Court also, my lord, in this regard, passed an order.
You find some other ruling which may help you.
Had the department proceeding not been initiated within the period, then would have.
Within that period, 3 months,
Lordship.
Yes.
if it is not served,
If it is not served,
memorandum of
Then Lordship.
not served, then suspension should go.
yes.
However, if it is
If
served,
it is served, within that,
then the order has to be passed.
if
That's
this
all.
served, memorandum of charge is served within the 3 months, then suspension will not be cancelled.
No.
That will continue.
Continue.
But question is that it must be passed within the 3 months,
No,
not after
there
6
is-
months.
There is no one within the 3 months. If the
No,
memorandum
it
of charge
continues from the
is
first
served,
line, my
a
lord. It is
reason
not-
order must be
This
passed.
is a semicolon. This
Ye-
is a semicolon.
Lordship.
So can it be on Friday, my lord? That
Okay.
I'll be on Friday or Monday.
On
Monday.
request made by Mr.
And how can it Monday, my lord?
And how blood of council. Mr.
Monday, my
Monday.
Monday.
That part only you come.
My lord, that clarification.
The matter relates to admission in PG courses, my lord. And the Council for National Commission of, my lord, that he has been given some time to take instruction, my lord.
1 minute.
The last order, my lord. Three ten order, my lord.
Have you filed your affidavit, Gogo?
Yes, sir. Affidavit, we have stated that, my lord, if the NMC gives the permission, we can increase. Also, you will kindly see, my lord, page 103. Our requirement is some 146 for the section 24.
1 minute. Yeah.
Running page 103, para 4. And this was reflected in the last order.
Yeah.
May it please your lordship. Lordship, on the previous date was the first instance where the NMC was implemented, lordship. And accordingly, my lord, instructions have been sought. I have sent a copy of the petition as well as the, my lord, apprised the department of the stand of the state, my lord. That is their willing and a requisite number of certain number of seats need to be increased as well. Now, if your lordship looks at the prior orders of this honorable court, my lord, then after a detailed calculation, a total number of 51 seats were increased, my lord. And subsequently, every year when the same issue was coming up, my lord, the stand of the NMC has been same, which has been upheld by this honorable court, that those 51 seats which have been increased once should be maintained on every year. Accordingly, my lord, the concerned department has written, and those 51 have been increased. However, my lord, keeping in the prayer of the petitioner as well as the stand of the state, my lord, and also another aspect has come in this time around, my lord, that is along with the EWS, there is an increase in the OBC reservation percentage also. So, my lord, there's a lot of technical and calculative measures which are being taken, my lord, and seat matrix being increased is being looked into. Maybe the figure would be different, maybe possibly more than 51 also. So, lordship, another 2 weeks' time is required for the calculation to be completed and placed before this honorable court. This instruction has come to me in written form that the increase into the lordship, that the increase into the sheets is being looked into, and 2 weeks would be required. I'll place the email to my lord.
Okay.
And my lord, there should not be any prejudice to be caused.
As Mukhtar and counsel for the petitioner. Stop. Mr. DK
Boyd,
the understanding counsel and submit that the authority are examining the increase of fee,
my lord,
as claimed by the petitioner, as well as supported by the state respondent.
Right.
And he therefore prays for 2 weeks back to receive appropriate instructions and also file affidavit.
My lord, either affidavit or written instruction, my lord, as in whatever form, my lord.
And or file affidavit.
And,
Praise the Lord. When do you want date?
The date may be fixed, my lord.
Yeah, this is list down.
Yes.
my lord, can it be on 8th, my lord?
Yeah.
8. My lord. Obliged, my lord.
My lord, 7th, if it's possible, my lord.
Yes, sir, no problem. 7th.
7th is convenient for lordship. 7.
Obliged.
7. Deeply obliged, my lord. Deeply.
9.
Pleases your lordship. Your lordship,
1 minute, let him start this.
instruction awaited your lordship.
Period is there.
This matter, lordship.
Instruction assigned. Let the notice may go, your
Lordship,
lordship.
call for lordship that records of the case. But they said the instruction has not yet come. Then lordship may kindly ask some interim order so that I get protection during this period. I was placed under suspension, lordship, on 9th of February 2024. Pending drawal up disciplinary proceedings against me.
Page number.
Lordship, that
Page number.
page number annexer 5, lordship, page 55.
90 days past.
I'll come to that issue later. First now,
Page number.
page 55, lordship. Lordship will kindly see that last but one para. Pending drawal of departmental proceedings, C. Sassensas, Principal Ajitullah Higher Secondary School, is hereby placed under suspension with immediate effect as per provision of Rule 6.1 of the Assam Service and Disciplinary Rules. The pending drawal of disciplinary proceedings, thereafter, lordship, the show cause notice is issued to me on 26 May 2024 at page 58, lordship, page 58. Which is a charge sheet, lordship. I did the second para, lordship, that while you were in service, serving as principal, such and such school, you were placed under suspension by the Director of Secondary Board Education, such and such, on 9/2/2024. In connection with the alleged allegation against you by the Deputy Commissioner of South Salmara, such and such, regarding misappropriation of government fund. Lordship, the law is very clear
The charge sheet, what is the charge? What is my commission? Illegal commission, illegal omission must be clearly stated so I can defend. Nothing is stated here regarding the allegations made by Deputy Commissioner. I am not here. That has not been supplied to me, Lordship. Now, in the statement of allegations also, Lordship, next page, which accompanies always the charge sheet. There also it's absolutely fake. While you are in service, serving as such and such, you are placed under suspension by the director, such and such, on 9/2/2024 in connection with allegations against you by the Deputy Commissioner. What are the allegations? Nothing has been stated. None of the allegations has been provided to me in spite of my asking. Lordship, charge sheet is not maintainable in law. Lordship, that 9(2), I just read out, Rule 9(2), Lordship.
May I please, Your Lordship, here your Lordship statement of allegation has already your Lordship issued against the petitioner on dated 26/5/2024. But here your Lordship, they had mentioned some office order numbers when so dated 9/2/2024 in connection with the allegations. So I need to obtain instruction in this regard, your Lordship, regarding this office order number. So I may be allowed some time to obtain instruction, your Lordship.
Don't take coercive steps against it.
Lordship,
No coercive steps shall be taken against.
Huh?
No coercive steps.
Oh, okay. Lordship, maybe state proceedings may be state, Lordship, because
I'm not saying the amount is, let us see what happens.
Yes.
But then, I'll pass in order, no coercive steps. shall be taken. But Mr. R.P.
Your Lordship. There is another angle of this matter, Lordship, if I may point out.
As stated by Mr. R.A.
A.B. Day.
Mr. A.B. Day.
Counsel for
Suspension appointed for this.
issue.
But Lordship, I kindly also observe that my subsistence allowance may be paid because they are not paying my subsistence allowance also.
MSP docs, then standing counsel,
Secondary,
secondary education, appears for.
1, 2, 3, 4.
All the way. Complete some respondents to complete, however, it's accomplished. Respondents are allowed final. List after 2 weeks.
2 weeks.
List after. Till the next. No coercive step. No coercive action shall be taken against the petition. So, further, the respondents are directed to pay the subsistence allowance
Immediately.
after following all laid down procedures. In accordance.
Maybe for extra copy, your Lordship.
I will provide. No problem.
If you.
Oblige.
10.
Here Lordship will find the impugn order at page 31. Page 31, my lord. 3-1.
Yes.
Now, my lord,
With the original order,
yes. Now Lordship will find, my lord, the original order, my lord. It is not visible, my lord. The, my lord, operative part Lordship will find at page 34, third para, my lord. Page 34, third para.
yeah,
Page 34, my lord. Yes. Order, my lord. In view of the above facts, my lord, it should be facts, my lord, and circumstances as per report of the DEO Dubri, as well as the DICE verification report submitted by the SS Assam. The name of the respondent number 7, Mokrom Ali, appeared in the DICE data against P. Basanipara BLP school, bearing dashboard number so and so from 2006, 2007, 2009, 2010 only. Thereafter, name appeared against Paschim Basanipara BLP school, bearing dashboard number so and so from 2010, 2011. Hence, the provincialization of service order issued white number so and so
dated 5/2/2021 of the respondent number 7, Mokrum Ali against P. Basanipara BLP School is hereby cancelled. Now, no reason has been given. And on the other hand, the name of the petitioner, that is Shahadul Ahmed, who filed the earlier case, against me. Shahadul Ahmed was not recommended by the DSC Dubri against P. Basanipara BLP School, bearing dash code number so and so, and also his name was appeared in the dash data against P. Basanipara LP School from the 2012-13, which does not fulfill the decision of the Joint Committee Minors dated 24/7/2020, as his name does not appear in the dice data from 2011-2012 and afterwards. As per the clause 2(1) of the Act 2017, the teacher should be appointed on or before 31/10/2010, and accordingly, his name may be included in the dice data latest by 2011-2012. Hence, the service of the petitioner Shahadul Ahmed cannot be considered under provision of this so and so, and he is hereby rejected. Now, Shahadul, who filed earlier case against me, that has been disposed of by this noble court, directing the director pass reason order that Lordship will find at page 26. It starts from page 25. The operative part at page 26. And direction part Lordship will find page 28, para 6 . May I read, page 28, para 6. It is an admitted case of the respondent number 7 that he is a teacher of Paschim Basanipura so and so school. The director of Eligibility Division Assam, upon examining the records, he finds that the respondent number 7 was provincialized in Paschim Basanipura BLP school, bearing dash code number so and so. Appropriate reason order may be passed. In the event, the director, upon examining the records, that the respondent number 7 was provincialized against the P. Basanipura Bansar LP school, having dash code number so and so, appropriate order may be passed for removing the name of the respondent number 7 from the list of the provincialized teacher and pass necessary order to bring the teachers of the P. Basanipura LP school having dash code number so and so in the list of the provincialized teachers, which may include the name of the petitioners if found correct and genuine. Now, once the petitioner's name is not entered in the dash data in between the cutoff year fixed under the Act, so his case was rejected by the director. But so far my case is concerned, I have been provincialized. My name has been included in the dice data. I have fulfilled the criteria as indicated in the order itself.
Dice data is there, but then the number of the dice data.
Yes, number of dice data. Initially,
This court was concerned about.
yes. But in total, after all, my name is recorded in the dice data. Dice data subsequently says that is not my fault.
No, your name is there, there's no doubt.
Yes.
But then the number, dice number.
Dice number.
That is what this court was concerned about.
Yes.
In the last order. So it says 041632.
Yes.
Having dice code number 7, appropriate may first removing the name of the respondent number 7.
Yes.
And the findings of the director, you read it.
Now, in the both dice data, my name is appeared because initially on dice data, subsequently it has been changed. It is not that my name is not included in the dice data. Continuingly, 2006 to onwards, even till date, my name is appearing.
Okay.
It is, my lord, it may be different school because dice data is different. And dice data, as per my.
We issue notice.
Yes, sir.
But Mr. M. Mondal, M.U. Mondal, General Counsel of the Petition. Issue notice.
Hello.
Mr. Chief
My lord,
Secretary, who's appearing for Chief?
My lord, here SSA is required for it because of dice data.
SSA has no role.
No, my lord. Dice data is.
SSA is required.
My lord.
My lord, dice is cleared, my lord,
No.
in my favor.
No.
No. Let the SSA, you make an eye.
I'm my lord.
Yes.
Fee cycle and governance. It applies for respondent number 1 and 4. Mr. J. Peku, standing counsel, elementary.
Yes.
Appears for respondents 2, 3,
4, 5,
6, 7, and 7. Treasury officer, Mr. B. Gogoi, standing counsel, finance department. Appears for respondent number 9. Petitioner to take steps for service of office on respondents 8, 10, and 11.
Well,
5 registered post 80 within 1 week.
well,
1 week. complete.
but register as well as smaller dasti time may be permitted.
But additionally, petitioner is also permitted to post service of office on the respondents 8, 10, and 11 by justice service. To reach the court within a period of 1 week.
Well,
1 week. After petitioner shall file an affidavit to the effect. Respondents are allowed to file it. Please, doctor.
4.
at least the
We issue is directly to reflect the name of the standing council, health department, finance department in the council.
My lord, SSA is required to because
yes, I will. Now, my lord, in the meantime, my lord, may I pray, my lord, since 2021 to till date, my salary has not been paid. So may I pray, my lord, before the my lord, cancellation order, that period, that salary may be my lord paid.
Let him get his instruction.
My lord. Oblige, sir.
11.
Lordship, recently the government of Assam has initiated a process of transfer of teachers from one place to another, from one district to another, as well as inter-district transfer, my lord. As such, petitioner in the year 2013 applied for the same. The entire process is divided into 4 phases. First, a teacher applies there. Thereafter, IS approves it. Then it goes to DLC. And last process is approval by the director, my lord. In my case, IS has already approved, my lord. And the matter is pending before the DLC since 2013, my lord. It's a 1 year, my lord. I have also filed a representation before the DLC in the concerned authorities, my lord, that I am approached before this honorable court as such, my lord. My humble prayer is this, my lord, that as the matter has already been approved by the IS and passed through the DLC, my lord, my matter has to be considered in the next DLC meeting, my lord. That is the deal.
Who is your representative?
My lord, may kindly peruse page 14, my lord, annexure 1.
No.
Representation is on
Representation, my
annexure
lord.
239, 2024, page 18.
Representation
18
is
and
page
19.
18, my lord.
You are drawing your salary from the other school.
My lord, because presently I'm working at Dhamdama College, my lord, but I was temporarily transferred from Bonbag to Dhamdama. In that, I was transferred Bonbag to Dhamdama, but that post has already been filled up, my lord. For now, the question for me returning that college doesn't arise, my lord, since the post is already filled up. Now I'm.
You are college or school?
My lord, this is different 2 schools, my lord. Initially, I was transferred on a temporary basis to another school. For last 4 years, I'm working there on a temporary basis. Since this portal has been initiated by the government, I applied for the same for transferring me permanently, my lord, to the other school. Since I'm drawing salary from the other school, my lord, that is there. Since my case has already been considered by the IS, is pending before the DLC, my lord. I'm came before your lordship, my lord.
Let the notice may go. It is
My my humble prayer is there, my lord. Since I have filed a representation, that may be your lordship may be disposed of the matter with the direction to consider by representation, my lord. The entire record is before the DLC, my lord. Nothing is there.
The DLC.
My lord. The matter, my lord, may kindly peruse for a moment, page 17, my lord. The earlier page 17, 17.
Yes.
Page 17, my lord. This is the status, present status, my lord. This is the present status, my lord. That's the application progress. First, the 4 lines are there, my lord. There's a teacher, then IS has already approved, then DLC, then directorate. The horizontal lines are there, my lord. 4 horizontal lines are there. First one, I have applied for the same. My lord.
No, where's the IS?
IS has already approved, my lord.
How do you know that?
That is the dark line, my lord, that I has already approved.
Where in the dark line?
There is, my lord. That is. IS is already approved. Now pending before the DLC.
Who's the chairman of the DLC?
The deputy commissioner, my lord.
Then you've been making a representation before the wrong authority.
No, my lord. I may kindly peruse the representation, my lord. I have made everybody, my lord. Page 19, my lord, for a moment.
18.
19, my lord. I've already given a copy to the DLC Nalbari and Akham Server 6 revision. I've already made a copy to the DLC also and Akham Server 6 revision also.
But that has not been annexed here.
We don't know whether the copy has gone. You have to address it to the DLC concerned.
I have also submitted a copy to the DLC also, my lord. Because since the director is the superior authority in the education department, my lord, the main copy is given to the director, my lord.
Yes.
On the basis of your lordship representation, it may dispose.
Mr. S.
Chaudhary
and the counsel for the petition, as well as MSP Das, the standing counsel.
Secondary.
Secondary education for the respondents. 1, 2,
5.
and 5. How about 3 and 4? Mr. B. Cycle and the government advocate for the respond number 3. And how about the Ahom Sarva Shiksha Abhijan Mission? And Mr. B. Gogol and the standing counsel. SSA. SSA for the respond number 4. Stop. Para. The petitioner was initially appointed as subject teacher.
My lord.
As a subject teacher at Paribak Senior Secondary School in the year 2006. Stop. Thereafter, petitioner was transferred from the, it is not Paribak, it is Banbak.
Banbhag, my lord.
From the Banbak Senior Secondary School to Dhamdama Senior Secondary School, Nalbari. In public interest. Due to absence of Assamese teacher in the segment Dhamdama Senior Secondary. Sorry. Till date, the petitioner is serving in the said Dhamdama Senior Secondary School. However, he is drawing his salary from the Banbak Senior Secondary School. Stop. In the meantime, the Assam government of Assam by virtue of the Ahom Sarbar Shiksha Abhiyan Mission, Rashtriya Madhyamik Shiksha Abhiyan, Assam, initiated the process of transfer of teachers who have completed a continuous period of 10 years and more from one school to another within the state of Assam. As the petitioner has completed almost 24 years of continuous service, met his application for transfer in the Damdama Senior Secondary School, Nalbari, as a regular employee on 6/9/2022. However, his case is still pending before the concerned district level committee for consideration. Accordingly, the petitioner made a representation on 39/2024 before the Director of Secondary Education. For transfer from the Banpak Senior Secondary School, Pokrapa, to Dhamdama Senior Secondary School, Nalbari, and a copy of which was also endorsed to the DLC Nalbari and the Ahom Sarva Shiksha Abhiyan Mission, Assam. Stop. However, till then, no steps has been taken. And accordingly, petitioner being aggrieved as by way of the president. Or as the representation made by the petitioner on 39/2024 before the Director of Secondary Education is yet to be considered. To whom will I give the direction?
First, your lordship, DLC has to be approved. Then thereafter, your lordship, director will.
A copy of which has also been endorsed to the chairman, TLC Nalbar. This petition is disposed of, directing the TLC Nalbar to consider the representative and pass appropriate orders for consideration.
Allocate complete whole goal.
Director is
Director.
for
Copy
consideration by the director of
but they
secondary
have
education
not.
within a period of 1 month.
2 months, your lordship.
1 month.
So DLC. Letter has.
As well as DLC also.
Copy has copy this.
Copy this.
Copy for info.
Then
petitioner may be directed to conduct fresh application for the DLC.
DLC.
Otherwise,
then you
But that will also.
that's only
Fresh like-
cancel the whole paragraph.
Yeah, they are next for.
This court, on consideration of the representation dated 39/2024 made by the petitioner, is of the constituted opinion that the petitioner should have met his representation before the chairman, TLC Nalbari. Accordingly, petitioner is directed to file a fresh representation before the chairman of the PLC Nalbari within a period of 2 weeks.
So within 1 week, I'll file
Within a period of 1 week from today.
1 month delay.
Thereafter, on receipt of the representation, the PLC Nalbari shall consider the same and dispose of the representation as well as pass necessary order for consideration by the Director of Secondary Education within a period of
1 month, my lord.
1 month, within a period of 1 month from the date of the representation. With the above
What?
observations and directives. Yes.
One line, sir. That representation have to be looked from the inspector of school.
Because all report that is pertaining to the inspector exclusion.
Inspector.
Inspector
already applied for his.
Inspector.
Representation
Okay. One thing is that, my lord, that the chairman / the deputy commissioner has to be there, my lord. The DLC has to be represented as chairman. The chairman is also a deputy commissioner.
Chairman is already there. Chairman is the deputy commissioner.
My lord. Represents a lot of people there. Oblige, my lord.
But Mr.
AHM Arthur.
Let me count. By way of the present with petition. Petitioner is claiming for errors with effect from 1/11/2020 to 28/2/2023. I. No, 22. It cannot.
1, 3, and 5, 4, 5.
All these petitioner.
Yes, my lord.
The petitioner, sir. Petition. Mr. G. Bexu. Leonard, standing counsel.
Respondent number 1, 2, 3, 4.
Elementary education affairs for the respondent 1, 3, and 4. 1, 3, 4, and 5. Finance.
Finance B go.
Mr. D. Gogoi, understanding counsel, finance department, affairs for the important.
Oblige.
13.
Yeah.
My lord, the petitioner retired 3 years ago as the principal in charge of the school. Or senior secondary school. My lord, the private.
2022.
My lord, yes, she retired long back. Now, lordship, at page T,
You retired 4 years ago or in the year 2022.
I retired on 31st January 2022.
Correct.
As the principal in charge, my lord.
Hmm.
Then this private respondent has again and again, my lord, bringing allegation against me that his pension paper were not signed, but he had got the pension long back. Now, lordship kindly see the at page 31. Page 31, my lord. Impugn order. So goes notice, lordship. In excesses of the powers conferred by the government notification number auto dated 5th December 1967, the undersigned hereby asks you to so cause under Rule 9 of the Assam Services Discipline Appeal Rules 64, why any of the penalties under Rule 21 of the Assam Services Pension Rule should not be inflicted on you on the following charges. Now, my lord, see kindly charges which have been once challenged. Charge number 1, that while you were in service and serving as a principal in charge of the Bezara Senior Secondary School under Cambridge district, you were found involved in not maintaining accounts of the institution, including cash book, operating the bank account single-handedly, collecting admission fees from the students of class 11 and 12, and not signing the final pension papers of the retired principal of the institution. You are therefore charged with the involvement in misappropriation of the fund, power, deterioration of the academic atmosphere of the school. These charges were brought as per the expert speaking order at page, my lord. I will show you, lordship, page 20. Lordship, page 20. In partial modification of this office earlier or issued number so and so, the following officers and the officials of this directorate are hereby appointed as inquiry officer and presenting officer to inquire into the matter relating to the public complaint petition against Srimati Sundharani Devi, in charge principal. Now, these are the persons appointed as inquiry officers, and these officers on their report, at page 21, Lordship, the director has held me guilty. Kindly see, madam. At page 21, madam, kindly see. Whether the representation that the 2120 has been received from the president and vice president of the SMDC. The president is respondent number 4. As well as certain number of public Bezara area Kamrup district, wherein they have submitted certain complaints against Srimati Sundharani Devi. Whereas this office, letter order number so and so, that 3621, this Malot inquiry report team has constituted to inquire into the matter relating to public complaint against principal in charge of the Bezara Anshalik Senior Secondary School under Kamrup. Now, Lordship, kindly the charges, some charges which have been brought again, not convening any meeting of the SMDC during her tenure, not maintaining records related to accounts, operating bank account, collecting admission fees, not signing the final pension papers. Already the inquiry team submitted the inquiry report, wherein they concluded that the allegations leveled against Srimati Sundharani Devi, Senior Secondary School under Kamrup is serious in nature, and she failed to submit so-called adequate proof to defend herself. The charges of not convening any meeting of the SMDC during her tenure, not maintaining accounts of the institution, including cash book, operating bank accounts, handle our gross irregularities committed by the principal. On the above facts and circumstances, and in the interest of the public service, Srimati Sundharani Devi, principal in charge of the Senior Secondary School under Kamrup is hereby relied from the charge of principal of the school. So this was challenged. And the Honorable High Court, my Lord, has, I have annexed the order. What she will kindly see. At page 25. And page 26 is the order. I will read the relevant portion. Page 27. Mr. Goswami, London Council submits that he has been instructions to appear on behalf of Respondent 4 and 5. If that is so, registry may accept any wakalatnamu. The petitioner is the in charge of principal of Bezara Anshalik Senior Secondary School. A representation dated 2011-20 was submitted by the President and Secretary. That representation, my Lord, on which basis again these charges are brought, along with some members of the public raising certain complaint against the petitioner. Pursuant to such complaint, an inquiry was conducted as per the order dated 3621. Presumably by the directors of Secondary Education Assam, the complaint raises certain serious allegations against the petitioner of having not convening any meeting of the SMDC, not maintaining records relating accounts of the institution, operating the bank account single-handedly, collecting admission fees from the students of class 11 and 12, respectively, and not signing the final pension paper of a retired principal of the institution. Pursuant to such order, at 3621, an inquiry report was submitted wherein the charges of not convening the meeting of SMDC and not maintaining the accounts of the institution are stated to have been proved. Without inquiry, they hold that it was proved. But upon such an inquiry, the order impugned dated 6/10/21 had been passed by the director of Seniority, ordering the petitioner from being the in charge principal of the school. The order by which the petitioner has been withdrawn from being the in charge of the school
school in the prima facie view of the court would constitute adverse civil consequence on the petitioner. Any order having adverse civil consequence requires a procedure of law to be followed. The inquiry report referred to in the order impugn at least at the best be a preliminary order report and cannot be constituted to be a report pursuant to any appropriate proceedings under the law. On a prima facie case being made out, the required procedure of law had not been followed, and considering the balance of convenience and irreparable loss, the petitioner may suffer. The order of impugn dated 6/10/21 is hereby stayed. So that order on which basis, again they have started the proceeding after my retirement. Lordship, will you kindly see how wonderful this private respondent.
Withdrew the writ petition, isn't it?
My lord,
You withdrew the writ petition.
that petition.
How?
After retirement, after
Yes, you
retirement
said-
petition becomes infectious.
So it has become instruction, you withdrew it.
Yes, my lord, after retirement, that petition, my lord, becomes infectious.
What happened
That's-
is that after the order was passed
My
by this court, staying that operation of so and so.
My lord.
order, they went on appeal.
On the writ bill. And the writ bill, my lord,
It was modified.
modified
To the
and
extent that you will not be allowed to take any
yes,
important decision.
yes,
All right.
yes.
After that, you will do the writ petition after the it's come instruction.
Infectious because I retired. Secondly, the allegations which have been brought, the Honorable High Court held regarding holding of SMDC, kindly another order is here. At page, Lordship will kindly see, at page 39. Because this lady was harassed by the earlier principal who has collected heavy money against whom this petitioner raised objection. Page 39, Lordship, at page 41 may be kindly seen. And IA was filed by this page 41. And Mr. B.P. Bora, Learned Counsel for the applicant. Applicant means my lord, present petitioner. Now also heard Mr. R. Mujindar, Learned Counsel for the respondent 1, 2, and 3, being the authorities under the secondary division department of the Assam. Mr. C. Goswami, Learned Counsel for the respondent number 4, private respondent, my lord. The interlocutor person is instituted by the applicant who is the insurance principal because that was an expert order. Being the respondent number 4 in WPC 287821, praying for a modification of the interim order dated 34/21, passed in WPC 2878/21. In the writ petition, the petitioner who is the president of the school managing committee, president of the school managing development committee, a short SMDC of the Bedara Anchalik Senior Secondary is agreed to the extent that the in-charge principal of Bedara Anchalik Senior School is undertaking certain constructions of the building in the school without having necessary permission and joint participation from the SMDC. In the course, in the circumstances, the applicant relies upon clause number 9 of the notification dated 416 dated 24/6/16 of the Secretary of the Government of Assam in the Irrigation Department. Clause 9, my lord, kindly see who is SMDC. Clause 9, the SMDC shall generate a school development fund by collecting grants in aid from government, RMSA, and any other sources, including collection of subscriptions, donations, etc., for development of the school infrastructure, building, furniture, drinking water, and sanitary facilities, etc., and to maintain bank accounts in any nearest scheduled bank, which should be operated jointly by the president and the member secretary, but no fee shall be levied from the students covered under exemption from the such payment in accordance with the rules in force and to be framed thereon, time to time. A reading of clause 9 goes to show that the SMDC shall generate a school development fund by collecting grants in aid from government, RMSA, or from any other sources, including collection of subscriptions, donation, etc., for development of school infrastructure, building, furniture, drinking water, and sanitary facilities, etc. For the purpose, a bank account is declared to be maintained in the nearest scheduled bank, and such bank account is to be operated jointly by the president and the member secretary of the SMDC. In the given case, it has been understood, that the in-charge principal of the school is the member secretary of the SMDC. In other words, in order to operate a bank account of the school development fund, same has to be done jointly by the president and of the SMDC and principal of the school. In the instant case, no matter is before the court to arrive at any conclusion that as to whether the purported construction of the building in the school concern is being undertaken by the insurance principal. We did not start any construction of the school by utility fund of the school development fund generated by the SMDC. We did not spend any money that could not do anything. Now a submission is made that the construction of the school building is also included in clause 9 of the notification dated 24/16. True, it is so. But such construction of the building would have to be from the school development fund as generated by the SMDC, and clause 9 of the notification dated so may not be applicable in respect of the construction of the building. In the instant case, we have taken note of the interim order dated 34/21 was passed on a premises that there is a violation of clause 9 of the notification dated 24/6/2016. In accordingly, the in-charge principal of the school was restrained from making any expenditure from the school fund.
Yes, Sankhya, what do you want? What do you want in this?
Now, my lord, this order should be suspended. Let them sue that this is the same so-called option which was set aside by the High Court previously in good for a cases. On same charges, they have again issued a so-called notice.
6/10/2021.
Yes.
By which you were relieved.
Yes.
Correct. That has already been modified.
My lord, that modified as part they have to start a new proceeding under the law. Under section 7, they have shown me the so-called notice as if they have made the inquiry and I am found guilty.
Thus,
Notice may go in this matter, your lordship. I need to obtain instructions.
see, here is an order. He's
Already?
challenging the appointment of the inquiry officer, which was done in 2021. Then he's challenging the order by which the petitioner was relieved from the in-charge headmaster, principal of the particular school.
Yes.
And he's also challenging the order, the show cause notice of 14/8/22. Now, this order by which the petitioner was relieved as principal, that has already been modified by the division bench of this court. It has already been modified.
Modified it.
And if they want to start the first proceeding,
Why do you want to challenge this order?
no, because they have asked me to so cause. Kindly see Annexure D.
That there is
They
not
are
valid
going
also, your
to
lordship.
they
It
are
has
going
become
to
infructuous.
on the Annexure D. Annexure D. On the same which they cannot do, my lord. And section 20, rule 21, I will show of the governor power. And annexure page 31, this have policy issued on 14/8/24. My lord, kindly see the pension rule. They are going to punish me under rule 21. Kindly see rule 21, governor power of the pension, my lord. My lord, Assam pension, my lord. This is Assam Services Pension Manual.
Manual.
Well, it is my manual. I am giving it to Lordship. This, Lordship, the such inquiry shall not be issued with the sanction or without the sanction of the Governor of Assam. Kindly see, my lord. A B1.
What is the book that you are holding?
This was my lord, was done by me. B1, my lord, B1. After retirement, if they want to do any proceeding, they have to obtain the permission of the governor.
page 31, annexure D, your lordship.
Yeah.
That show cause notice, your lordship, which was issued on 14/8/2024.
Yes.
Here, your lordship, it was mentioned that in exercise of the powers, I would like to read, your lordship. In exercise of the powers conferred by government notification number so and so dated 5th December 1967, the undersigned hereby asks you to show cause under Rule 9 of the Assam Service Discipline Appeal Rules 1964. Why any of the penalties?
1 minute. Come to annexure A. A departmental proceeding was already initiated in the year 2021,
2021.
before the petitioner's retirement. Is it correct?
Yes.
Is it correct that the departmental proceeding was initiated against you?
My lord,
Because there was already an appointment of the inquiry officer.
the departmental proceeding, they should have started, my lord, as per the law. They have issued the show cause notice and they are going to impose the, why any of the penalties shall not be imposed.
Yeah, Sakya, you are not getting me.
My lord,
By your own annexure A,
my lord.
by 30/6/2021,
Lordship, just a minute.
inquiry officer was appointed.
Yes, my lord.
That would mean that there was already a departmental proceeding initiated against you before your retirement.
Yes,
Before your retirement.
I have challenged that,
Before your retirement.
my lord.
So this application of 21B1 will not come.
My lord.
It was already initiated before your retirement.
No, that proceeding, which inquiry had been started, that by inquiry I was not allowed to participate. That an inquiry, that is why the High Court interfere. And the double bench, my lord, directed them to start a fresh proceeding if necessary.
Okay, heard Mr. R.C. Cycle and Counsel. Issue notice. MSB does, Learned Standing Counsel. Secondary Education appears for the respondents.
Respondent 1, 2, 3.
And who is respondent number 4?
My lord, the private student who is doing all these things, principal, ex-principal. I have given the address. He is the man who is doing all these things.
Extra copies of petition.
I will take steps for him, my lord.
Petitioner to take steps for service of notice on the respond number 4 by registered post 18. Within 1 week from today. Respondents are allowed to file a list of the 4.
Interim order, my lord, it should be suspended, so cause.
Where's your prayer for interim?
Yes, my lord. My lord, there is the prayer, interim prayer, lordship.
Where's your prayer for interim?
Interim part has not been.
Lordship, just a minute.
Like,
Oh, my lord, that page is not annexed here. Sorry, my lord, that page I have typed. That may be kindly condoned, my lord. But the interim, my lord, they should be restrained. Otherwise, they will go on. I will annex that order. Prayer.
That is wrong.
Tomorrow, I will.
You're making a wrong submission.
No, lordship, this page. Let me
Prayer portion is page 18.
My lord. Yes, it is true, but let
And
me.
your affidavit page is 19.
Correct, your lordship is
How
correct.
do you say that there was one prayer?
No, my lord, that I will file an affidavit with the interim prayer, my lord. Kindly, my lord, because during this vacation.
If that is what you're trying to say, that's fine.
No, your lordship is correct.
You should say that you forgot to annex one page.
I'm sorry, lordship, because I was not well also. And this page, lordship, this interim prayer, I will, my lord, and file an affidavit.
Not an affidavit, you'll have to file an IA.
I will file. Oblige, my lord, oblige.
That is up to you.
No. Because sometimes some error is crept up by us.
Yes, Bora.
Lordship, impugn orders at page 62, 63, 64. Lordship, what has happened? Lordship, initially, a amalgamation order was passed on 18/1/2018. Thereafter, I challenged it. There was interim order, so the amalgamation order was not given effect to.
in 2021, a fresh policy came. Initially, by a policy of 2016, my amalgamation was made. Thereafter, during when it was stayed, a fresh policy came on 3/8/2021. This matter was heard on June 23. Now the government did not place that the original policy has been superseded by the new policy. And a order was passed against me. Now the government is implementing the policy which has already been superseded because of the High Court's order. Lordship, I'll place everything. Lordship, at page 21, 19, Lordship will find my initial amalgamation order.
Your school is?
School is, it's Baksa ME Madrasa School. It has 401 students, Lordship. The high school has 238 students.
No, you are Zakir Hussain Public
High School. It is amalgamated with Zakir Hussain Public High School, but my is a ME Madrasa, Bizni ME Madrasa. Now, Lordship would see the policy at page 21, the earlier policy. It is done by this policy. This policy, Lordship. Now, Lordship would see at page 36, page 35, Lordship, initially it was stayed, Lordship. Page 35, Lordship. Third paragraph, pursuant to a scheme dated 22/9/2016, enabling the authorities to amalgamate two schools depending upon the number of students and teachers. The petitioner's school, Bizni ME Madrasa, are amalgamated with Zakir Hussain Public High School by an order of 18/1/2018. It is contention of the learned senior counsel of the petitioners that the school has 401 students and 11 number of teachers, which is itself satisfy the requirement of RTE Act. So in the next paragraph, Lordship, in the instant case, the figures pointed out does not support such a contention on being prima facie satisfied, and also considering the balance of convenience and irreparable loss the petitioners may suffer till the next returnable date. The orders of amalgamation dated 18/1/2018 shall not be given effect to. Yes. Now, Lordship, what has happened? After that, a speaking order was passed. Thereafter, we challenged that also. Lordship would finally at page 43, Lordship would see page 43.
Yeah.
It's 43, Lordship would see that date 21/6/2023. This an order was passed against me primarily on maintainability ground, but since the matter was pending for long, the merits was also looked into. But my primary contention was not dealt with. I have filed an appeal, which is in the
your writ petition was number 679, is it?
That only, Lordship. 679, I challenged the amalgamation order. Thereafter, a fresh speaking order was passed. Again, I have challenged on 6592. In 6592 also, initially on 24/9/2018, that I should have annexed an interim order was passed. That is there I have seen. Thereafter, finally, in 6592, this order has been passed. At 17 and 18 is the operative part, page 48.
Yes.
Edu.
In 6592, the initial order was on 24/9/2018, Lodge. That is there. After after hearing the parties and on consideration of the materials on record, this court is of the considered opinion that a writ petition of this nature made by certain guardians of the ME school is not maintainable. As no legal right whatsoever of a guardian of a student is involved by amalgamation of a school in question with the high school. The 4 number of guardian petitioners were also members of the SMC of the ME school. There is no vested right to continue in the same capacity and the member of SMC as the SMC itself is for a particular tenure. Further, para 3.1 of the office memorandum dated 22/9/2016 makes it clear that on such amalgamation, it is only the SMC of the high school that shall continue and SMC and other schools would be withdrawn and such SMC would be reconstituted with inclusion of 2 representatives from the guardians and 1 from the teachers of each school amalgamated. The courts have already recorded that the validity of the office memorandum dated 22/9/2016 has already been upheld by the court and affirmed by the Honorable Supreme Court. Although the court is on opinion that the writ petition in the present form filed by the petitioners is not maintainable, since the petition is are pending since long and arguments advance on merits, therefore also being dealt with by the court on merits. Therefore, Lordship, finally at para 20, my writ petition has been dismissed. Now, Lordship would see at page 50. This is the fresh amalgamation policy on 3/8/2021. Lordship would find the date at the top. Yes. Now, Lordship would find at page 56. Last portion. Yeah. Clause 20. The notification supersedes the earlier notification number so-and-so dated 22/9/2016. Now, when the order was passed, the government should have brought to the notice of the court, Lordship, that this has already been gone. Therefore, when was the order passed? It's 21/6/2023. Lordship would find at page 43. Okay. 43 now it's this has already come in 21. Therefore, Lordship would see the whether what is the bindingness of death judgments which have been passed through a repeal policy. That is another question. Lordship, now what has happened? Now the interim order at page 62. We have already filed an appeal, Lordship. It is in the condonation stage and the order is at page 62. Now at page 63, may I read 63? The Director of Education BTC is hereby allowed to continue Zakir Hussain Public High School business as per amalgamation order dated so-and-so under Section Khetra scheme with existing government rules and procedures. This is issued in compliance with the Honorable High Court's judgment dated 21/6/2023 passed with BTC by so-and-so. Now at page 64, the Inspector of Schools dissolves the SMC of the ME school. Yeah. Now at page 65, we have been asked to hand over. The charge. Now, Lordship, I have challenged these orders. Now, these schools have 401 students, Lordship. As per the RT Act also, if a school exceeds 100 students, as per the schedule, Lordship, I will show, then a separate headmaster is required. A separate, so as per the rules also, this school could not have been amalgamated, firstly. Secondly, when the scheme itself was gone, the government had to point out in 2023 that this is, so if it was pointed out to the court at that stage, a completely different order would have come, Lordship. We have already challenged that till Lordship will examine that, Lordship, till then status quo may be maintained. If I don't know what is the position of charge till yesterday, academic charge was handed over. And financial charge, anything was not handed over. So Lordship,
You were supposed to do it by 3/10/2024. Hand over charge.
yes, Lordship, for that, Lordship, so I have been told that some coercive measures have also been contemplated, Lordship. So no coercive measures may be given, Lordship. That's all. Taken for not complying.
Yes. What is the issue, madam? What is the issue? You have 40?
It is serious. 7 to 11.
Secondary? I'm sorry, you Sharma, this is coming. Yes, what is 1, 2, 3, 4, 5, 1, 2, 4, 5. And take this elementary. For 1, 5, Mr. G. Pekul, understanding council elementary, appears to respond number 6. And Mr. R.K. Mushari,
7 to 11.
standing council PTC.
7 to 11.
Correspondence 7 to
11.
11. Stop. Extra copies. Petitioner takes step for service of notice on the respond number 12 by registered post 18 within 1 week. Stop. Who are the petitioners here?
Lordship, they are the members of the SMC president and other members. Lordship, there is no fault on locus, Lordship, this time.
Petitioners allowed,
Members of the SMC of
this the matter up to forward.
Lordship, some status quo orders.
What status quo order do you want? You've already handed over the
No.
academic charge.
Financial charge I have not handed over, Lordship. So they are contemplating a coercive measures. That's all, Lordship. Such no coercive measures may be taken.
Okay, till the next reasonable date, no coercive step be taken against the petitioner.
For non-handing over the charge.
Against the petitioner.
Again.
52 of supplementary list.
Lordship, the interim order of 6592 has already been placed before this court.
Okay.
আসলো কিন্তু টাইম তো রান আউট
Well, what has happened in this case? The petitioner before your lordship, she is a patient of thalassemia. Now, during the preliminary examination in the GMC, just before the counseling process, she was deducted, her medical documents of 2019-20 were examined. And they said that she has beta, she doesn't have the thalassemia within the benchmark disability. These are all very cryptic and not very clear. But to put at rest all things, my lord, what during the pendency of this writ petition, the petitioner subjected herself for a medical examination before the All India Institute of Medical Sciences, Guwahati. Now there is a judgment of the Honorable Supreme Court which has come, my lord, which says that now in case of disability certificate in regard to medical admission, the All India Institute of Medical Sciences in all the states where it has, it will be the competent authority to decide. But here I have, since I came to know about the Supreme Court judgment, so I have myself gone to the AIMS and done and they have said that I have intermediate thalassemia. So I think, my lord, there are a series of matters before this honorable court. We are running against time.
Yes.
The 30th October is the last date. But normally the last date is August.
No, it is the last date.
No, just let me. They have to show that by making oral submission will not do. Malad, as per the Supreme Court judgments of all the other cases, Your Lordship, the last date was August 30th. Then during the corona time, that period was extended because that was exceptional circumstances and specific applications were filed before the Supreme Court. But so far the current year is concerned, neither the National Medical Council nor the concerned state or medical concerned medical colleges have taken any specific time extension from the Honorable Supreme Court, because the judgments of the Honorable Supreme Courts are clear that without the orders of the Supreme Court and exceptional circumstances, you cannot extend the time. But this year I find, my lord, that the National Medical Councils have issued a notification, and on the basis of that, they are fixing the date October 30th. But I don't find anywhere or any reference of this particular academic session whether extension was indeed taken by the National Medical Council from the Supreme Court, because they have to follow the guidelines of the National Medical Council. But this year, I don't find any such, if they can place that order of the Supreme Court, because otherwise this is all, even if Your Lordship directs tomorrow, if someone goes and challenges it that it is all beyond that period, then it will be a exercise in futility. And in the meantime, my lord, my friend is requesting a time till Friday. But ultimately,
they have filed a reply.
Yes.
Is not part of the record.
Yes.
So I'd like to have the
It has come on the record. It has come on the court's record. He is asking for 24 hours to look into it. I have no objection. But only thing is that now Your Lordship will have to look into the large judgment of the Honorable Supreme Court, which was delivered on which was delivered on October 15. It says that now the appropriate authority will be the All India Institute of Medical Science. Because if I go to the GMCA, they will, by hook or by crook, they will try to defend their earlier order. Even I can show it from the reassessment done after filing of this writ petition, which was not done on the day when my application was rejected as no. So now, but only in the judgment, it's as a counsel of this court, I have to point out that observation so far, that All India Institute of Medical Sciences, that notification of the National Medical Council is already on record. But they have short time for implementation up to 24-25, the next academic session. But since there is already a notification of the National Medical Council that the All India Institute of Medical Sciences will be the appropriate authority, I would, all the petitioners or all these pending cases has to be now subjected to the medical examination by the All India Institute of Medical Sciences.
Let him produce the Supreme Court judgment. We can go through it today itself. Let him place it now. At least. You have a copy?
Yes. I have a copy.
Let it be printed. We say that it will be applicable from this session.
Lastly, I have brought to the notice of the court, and now he's trying to use it against me. That's I've been fair enough. No. I have made it. See, it says All India Institute of Medical Sciences and all places should be designated for issuing certificates of eligibility for attaining medical education. We should look into the spirit of the order. Spirit of the order is that you have to subject yourself to a medical examination if they arouse any doubt. So All India Institute of Medical Sciences is in Guwahati. They cannot say that All India Medical Science we cannot. And Your Lordship will see, I have pointed out that in any event, he said, we have no reason to doubt that the National Medical Commission will expeditiously comply with the requirements in the communication of the Ministry of Social Justice and Empowerment dated 25/1/2024, which is of January. And all this process started from February. In any event, we direct that the needful be done by the National Medical Commission before the publication of the admission brochure for the academic year 2025-26. But the intent and the purpose is that the All India Institute of Medical Sciences will do it. But otherwise, because what has happened in this case also, first they just gave a clinical note. They did not give any finding. Subsequently, when I took a specific ground that no hematologist was present to say my thalassemia condition, then they want reviewed. And they don't say also that I don't have thalassemia. They only say that I don't have a particular disease of HBE, which leads to anemic conditions. So that's as a counsel, as a assistance for the court only, I have placed it. Your Lordship may look into it, madam.
Okay.
So on Friday, my lord.
Mr. B.T. Conway, learned senior counsel. For the petitioner submits that he has filed an affidavit reply to the affidavit opposition filed by the
State respondents,
by
my
the
lord.
respondent number
5.
this morning.
Yes.
This morning. Is to verify the September report. On request made by Mr. Gogol, learned standing counsel health department. This is the matter. When do you on Friday? Or
Friday. We are running against them.
Possibility of time.
25. This is the judgment?
Yes, madam.
I'll go to.
My lord, in some of the cases, national medical councils have also appeared. Your lordship will kindly observe that they will produce the Supreme Court order extending the time up to October
That
30th.
is not the subject matter of the.
No, that's a subject matter because otherwise any order passed by this court will be a nullity.
Will see. In all India, my lord, this is the schedule. We can do it.
My lord, interim order will be extended, my lord. Item 35 also same order. In that case, they have filed their opposition today. 34. One is next to 34, man. You're not filing.
Let it be called serially, madam. I am
Yes, sir.
confused. Let it be called.
Quality. In that case, I'm sorry, my lord.
Lordship may.
Because they have not filed a reply in 34, so my presence may not be required, my lord. Lordship will fix it on Friday only when it is called. We are blessed.
Item 34.
Yeah, 34. But they are yet to file their reply in that case.
You want it on Friday?
Friday, my lord. And interim order will be extended. My lord.
Please, your lordship.
53, 54.
Same subject matter, my lord.
Yes.
This is, my lord.
54, I have a paravise report.
Ah.
54, no. 53, my lord, I have got a paravise comment, my lord, yesterday. I am preparing it and I will file it by tomorrow.
Yes, the matter, sir.
So on Friday, it is
WPC.
taken up.
Okay, heard, Mr.
MK Das, my lord.
Learned counsel for the seat. Mr. B. Gogol, learned standing counsel health department, submits that he'll be filing affidavit in opposition by tomorrow.
Yes, sir.
24/10/2024. Stop. 25th.
Yes, sir.
Accordingly, list the matter of considering the urgency involved. The matter on 25th. Then.
There is an interim, my lord.
Order passed.
Deeply obliged.
No, no,
My lord. There are other matters, my lord.
What about 54?
Admission or not?
Yeah, no problem, yeah. In 54, lordship, they were supposed to get instructions if otherwise I'm eligible on merit or not.
Yes, my lord. If my lord, that certificate is produced, she can be admitted, madam, under the TCL category. With the counter signature of the director. My lord, this is my concern.
That is the issue involved.
Yes.
Otherwise, you will be eligible, considering our merit pay. So now it's up to the committee to, my lord, verify and.
So who is in charge, who is appearing for the committee?
The last occasion, they have submitted that there's no complaint being filed before the committee as yet. So even if it complaint is filed, it will be subject to the outcome of this writ petition. Report to a challenge. Committee is appearing.
You are appearing for the committee? Yes.
Till that we have not received any communication.
Come to the mic, I find.
Lordship, till date, we have not received any communication from the Deputy Commissioner.
Then. Right here.
My lord, yesterday, my lord, Deputy Commissioner, he has passed an order as the
Passed what
Deputy
order?
Commissioner, my lord, to pursue the matter. According to will, my lord, place it. Within short time, we will place it.
See here, the admission is already started. Petitioner has qualified, but they cannot give him admission because of the complaint with regard to his TGL and ex-TGL certificate, which the Director of Tribal Affairs refused to.
He has already
understand.
forwarded.
All right.
Deputy Commissioner.
Now they are making communication between you and the Deputy Commissioner and the Director, instead of referring it to the Caste Committee. Caste Scrutiny Committee. What are you doing? You're trying to kill one candidate.
Absolutely, my lord. That's even my lord, they Deputy Commissioner
What,
have
what,
no
what
information.
order did the Deputy Commissioner pass yesterday?
My lord, they have only passed an order that re-verification of the caste certificate. My lord. They have attached to the.
How can you re-verify the, I don't understand.
My lord. Even my lord, I personally talked with the person concerned. My lord.
Is the Deputy Commissioner aware that in terms of the Supreme Court order, the government of Assam has constituted a Caste Scrutiny Committee? Is this, at least is the District Commissioner aware of this?
My lord. Definitely, he has to evaluate.
Now he has again, really.
Today, my lord,
to the
probably-
additional District Commissioner.
My lord, today probably he will forward it to the.
At least have you instructed him that there is a Caste Scrutiny Committee constituted by the government of Assam in terms of the Supreme Court's order? At least have you told him?
My lord, I have already intimated about that. Even I asked that on in July, Director of P-types and Adivasi Welfare sent you a letter. What is the status of the letter? Even that information also not come from the Deputy Commissioner. That is the difficulty. Now I said that you have to send to the Commissioner to the Social Justice and Environment Department to place the matter before this to be complete. Probably today, my lord, that letter will be issued.
Medical Education Department is saying
My lord.
that the petitioner is selected for admission into the first year MBBS course. However, due to non-submission of the TGL, ex-TGL certificate, countersigned by the Director of Tribal Affairs or whatever.
There is a form 6.
There is a forms, my lord.
They are unable to give him admission. That's all.
That's what.
And here the Caste Scrutiny Committee is saying Deputy Commissioner has not given them
not
anything.
Correct.
Otherwise, I have a valid caste certificate till date.
Even my lord, they assured today they will send it.
And
Let it be taken up tomorrow. My lord.
Yeah,
Tomorrow, my lord.
If it is placed, then lordship may give.
When is the last date of admission?
admission results has already been declared, but once it has been kept vacant.
That's fine.
If I may pray, your lordship, see, even if they place it before the committee, there is an entire procedure laid down. There are two notification.
It will take time.
Time, and that is also subject to writ petition, and then thereafter to Supreme Court. So this process will take time. So I am praying that my provisional admission may be given, because otherwise I have a valid caste certificate.
Oh, but lordship will.
Shall we take it up on Friday?
Yes, on Friday.
My lord.
Friday, I'll pass the order on
Yes.
Friday.
Yes.
Let us see what happens. At least whether the Deputy Commissioner having some sense or not, to at least send it to the Caste Scrutiny Committee. But Mr. R. Sharma, Leonard Counsel. On request made by P. Saikya, Leonard Governor, appearing for the District Commissioner,
District Commissioner, Sonit.
Sonitpur. List the matter on 25th October.
Obliged.
Interim is
Till today, it may be extended in the next.
If you have not sent it, and even if you have sent it on Friday, at least provisional admission will have to be given, which will be subject to the outcome of this proceeding.
Well, it will be subject to outcome of the report. That is what the report has said. If it is found that he is not eligible, he will have to vacate it.
That's
Very clear in the.
That notification is also part of this report.
More time.
My lord.
Only one aspect, my lord. There there are 5 years and 3 chances. So that's over by 2020. But since my lord,
Okay, let him get some instructions and come back.
My lord, in that case, if the date comes up for filling up of exam, so I will not be able to fill up the examination.
When is the date?
next week.
We'll have it on Monday then.
My lord.
What I does, MSI does. Then the council publication on request made by PG Foucault. Then a standing council for the university. List on
28th of October.
Most of it.
28th of
15, implement of party.
Please, your lordship, I for implement the new incumbents as contempt number 5, 6, and 7, lordship. 4, 5, and 6.
new incumbents
Yes, lordship.
in the contempt.
Yes, lordship.
Okay. Third
S.A. Khalifa.
is
S.A. Khalifa.
Khalita Learning Council for the applicant. By this application, the applicant, who was the petitioner in contempt case number 577 of 2022, is praying for implement of page 3, huh? A to 8. 3 and 4, page 3 and 4, 8 to 8. But don't give the serial number, but as 1, 2, and 3 as party respondents. 4, 5, and 6.
Yes, lordship. 4, 5, and 6.
In contempt case 577 of 2020, on the ground that the earlier incumbents have retired or transferred out, and the present proposed incumbents are holding the post. Stop. On consideration of the cost shown in the present application, this court is satisfied. Accordingly, the prayer for implement is allowed. I is disposed in the main contempt in view of the order passed to the I so and so. Let so and so be implemented as party respondents 4, 5, and 6 in the present contempt petition. Issue notice to the respondents 4, 5, and 6. Petitioner to take steps for service of notice on the respondents 4, 5, and 6 by registered post AD within 1 week. List after 4 weeks.
16, admission.
Actually, I'm paying for the adjournment for the day matter, Lordship.
Why?
The senior counsel, Exibor, my senior Lordship. Because she was there, but feeling unwell, Lordship. She left.
Okay, on request made on
40 day
behalf of
only.
Mr. S.J. Barua. Then the counsel for the petitioner, list after 1 week.
Actually, interim order was there.
Interim is there?
Yes. Lordship.
Interim order passed away to continue till the next day, till the next week.
Next week, Lordship. Last week.
Yes, you, Sharma.
Yes, ma'am. My lord, as per last order, my lord, serial number 2.
7, 2 and 7.
And 2 and 7, my lord, serial number 2, Abdul Sattar Mia. His pension is finalized, my lord, and he was expired on 17/10/2023, and his wife Mofida Khatun has got the family pension, white PPO number so and so from the director of pension office. And my lord, serial number 7, expired assistant teacher of Fakrul Ulum High School and expired while in service 8/8/2017. Her family pension papers forwarded to the director of pension Assam. After meet up the objections, this office of order office memo number so and so And now Hafiza Bibi have got PPO number so and so from the director of pension. This is the instruction here.
What about the other petitioners?
Other got my
Others
lord.
already-
Other has already got mine. Only 2 and 7 was left out.
So 2 has got it.
Lordship. As per their instruction, all they have got.
So you take instructions.
It may be closed, my lord, because this is official order.
Mr. U Sharma, the standing counsel. Secondary Education Department. As furnished, communication dated 27/9/2024. Wherein it is stated that the petitioner number 1 expired on 17/10/2023, and his wife Mofita Khatun is being paid the family pension via PPO number. Is being paid the family pension. Stop. As regards the petitioner number 7, it is also stated that she expired while in service on 8/8/2017, and her family pension papers have been forwarded to the Director of Pension, Assam, after meeting up the objections. Made in the letter dated 13/3/2024. Stop. No, petitioner number 7 is Hafija.
My lord.
Hafiza Bibi,
Hafiza is the wife of teacher, my lord.
wife of late Hazrat Ali.
Hazrat Ali.
Hazrat Ali, who was
It is
teacher.
also stated that as regards the petitioner number 7, who is the wife of late Hazrat Ali,
Assistant teacher
who
of
expired on 8/8/2007, is being paid the family pension after meeting up the objections made by the letter dated 13/3/2024. Stop. Para. Mr. R. Ali, learned counsel for the petitioners, submits that the present petition was surviving only for in respect of the petitioners 2 and 7. And as the said petitioners are now being paid the family pension, the writ petition may be closed. Stop. Recording the submission made by the learned counsel for the petitioner. Writ petition is accordingly closed. The communication dated 27/9/2024 is placed on record.
Speak low,
18.
Lordship, in this matter, the pleadings are complete and it is ready for final disposal, Lordship. It could be taken up on any other hearing day, Lordship.
You want rule to be issued or you want it in the admission stage?
In the admission stage itself, Lordship.
Okay.
Maybe after 4th of November.
Okay, it is submitted by the parties that pleadings are complete. Stop. Accordingly, release the matter for admission hearing when?
After 4th.
Lordship, any convenient date, Lordship may give in the first week of November.
7th.
Lordship. Much obliged.
19.
Yes, Your Lordship. Lordship, the respondent number 9 has filed an affidavit. Yesterday, we received a copy. We'll be filing a reply. Just 10 days time may be granted to us. Probably the affidavit is also not tagged with the record.
Respondent number 9.
Nine,
You're
newly
the
pleaded,
9?
newly pleaded.
When did you file your affidavit?
Yesterday, Your Lordship.
Yesterday. You on time?
Yes, to file a reply.
You are Mr.
S.A. Riaz, Lordship.
S.A.
Riaz.
Rias, learned counsel for the respond number
9.
9 submits that he has filed affidavit in opposition on 22nd, 22/10/2024. He is to verify and place a same on record. MSD Borgohen, learned counsel for the petitioner, prays for 2 weeks' time to file reply to the affidavit in opposition filed by the respond number 9. Praise a lot. List after 2 weeks.
20. Twenty.
None appears for the petitioner.
May I please your lordship? Lordship, I am for respondent number 8, but my senior's name is not shown in the cost list, lordship.
Who's your senior?
MU Mahmood.
Mr. EU Sharma, learned standing counsel.
Secondary education.
Secondary education, standing counsel appears for the secondary education department. And Mr. D Das, learned counsel appearing on behalf of Mr. B Sharma, learned appears for the Accountant General Assam staff. Registry is directed to reflect the name of Mr. M.U. Mandal.
Mahmood, lordship.
M.U. Mahmood, learned counsel for the respond number 8 in the cost list. List after 2 weeks.
21.
Sorry, madam. Item 20. 20.
21.
What earlier matter, Lordship? They have made that was just.
Okay, on top, say, don't say non-representative, say SP.
Madam, on Monday, my lord.
After 2 weeks.
Madam, kindly Monday, madam. Pension.
Pension matter.
Monday, my lord.
Okay, where's the matter? After a week, yeah.
21.
Regarding the availability of vacancies, already affidavit is filed. And the concerned inspector of schools also submitted its report, saying that Lordship, there are still vacancies after this selection is over. So last occasion, the department was directed to obtain.
As per last order, my lord, interdepartmental communication is going on, my lord, and director written to the inspector of school regarding the vacancy position, and now it is, my lord, awaited, my lord, this is the communication.
No, Lordship, the concerned inspector of school has forwarded the report after filing the RTI application. So report is not before the authority. So my prayer is that let the director scrutinize the record and pass a necessary order, Lordship.
Already, my lord, communication has been made to the inspector of school and inspector,
That's true.
and it is awaited that from his side that response has not come.
If my learned pay going through my the
No,
affidavit.
see, Sharma,
yes,
if you're going to keep on taking time like this, there's no point in giving you time. If you say that you're coming with some proper instructions, then I'll give you a fixed date.
Yes, my lord.
Otherwise, on the next date, I'm disposing. He's asking for an INUCOS order.
Yes.
That's all.
So one date may be given. Already communication has been made by the department. So one date.
Okay, heard Mr. A. Dekal and Counsel for the petition. Mr. U. Shamal and Standing Counsel Secretary Education. Placed for a short time as last chance to enable him to receive instructions. Praise the Lord. List down when?
After a week. Definitely. No hearing the Lordship.
7th?
7th.
7th.
An observation that endeavor will be made to
An
dispose.
endeavor shall be made to dispose of this petition on
So
the.
there is the interim order that may be continued.
Interim is there?
Yes, there.
Interim order possibly to continue till the next settlement.
Deep level.
22.
My lord, here, this petition was the head of the department, and such stigma was imposed by writing some adverse remarks on his service book. But the show cause notice was page H 33, annexure H page 33. The allegation, there is two allegations. Some of the students of the botany department was debarred from appearing in the examination because of lack of percentage, appearance percentage, that should be 75. And second,
1 minute.
my lord, this is the show cause notice, page 33, annexure H, 21/10/2022. The principal of this college, Guwahati College, is with the first show cause bringing two allegations.
Yes, then
he has made a reply. And next page 34, annexure I. Next day he replied. He said that debarring some students from appearing in sessional examination is the collective decision, and there is a norms on Guwahati University that 75% attendance is required. That is why they have taken a collective decision. And secondly,
1 minute. Yes.
so the decision is annexed in page 31, annexure G. Page 31, annexure G. 11/10/2022.
Page 31.
Yes, annexure G. So in botany department, HOD as well as other faculty members, they have taken a decision that the students who has not attained the 75%, they may be debarred. So this is a collective decision. After that, so he replied that it was a collective decision and this is norms of the Guwahati University. Sessional means, your lordship, it is not a final examination. In the department, they have tested sessional marks. Some
Sessional examination is important.
Main examination marks not.
It is not the final examination.
Yes,
but
session.
You have to get through the sessional examination.
Yes, that some students are debarred initially. Later on, they are given the chance, opportunity. So that is common later on. So this is the allegation that why you have debarred some students. Second allegation is that SEC marks was not uploaded to examination committee because SEC marks means skill enhancement course. That marks should be uploaded in GU portal because it is a bearing on the marks. So these two allegation was made. So to that, the petitioner has replied that the debarring of students is it is a policy and there is a collective decision. And secondly, he's alleged that that marks he want to give the examination committee, they refused to accept, and portal was not working. That is why by that time that was not uploaded. So he is helpless. Then second show cause notice was given again, 35, page 35, annexure J. Here also same allegation was brought, and the prohibition of some students and SEC marks was not uploaded. And his first reply is term is absurd without any basis. There is no reason why it is absurd. What is it? The second reply. This second show cause and reply is page 36, my lord, second show cause. Here he clearly says C, column C, whereas the practical marks of the paper in question SEC SE 403 has already been received by member of examination committee Dr. UK Chawra on 17/10/22. He's clearly said that this was handed over. And regarding these students, debarring students, they said that we have made an alternative arrangement and they are allowed to sit in the exam and their marks also sent to it. That is column number F. Additionally, it is for your kind knowledge that we have submitted all the sessional marks of exam committee in time, including the earlier prohibited students. Those students were although prohibited as a disciplinary measures, but later on some special arrangement was made. They are allowed to sit in the exam and their marks also sent. So there is no harm to the students also. But the impugn order, page 37, in spite of this clear, all the clarification, and page 37, this impugn order was passed by the principal, saying that your answer is not satisfactory. So his headship is taken away and is and said the unjust variation of the reply. Your reply clearly suggests uncooperative attitude, college authority with college authority. So he is debarred from functioning as a HOD with effect from 28/11. After that, this charges was taken over. Then kindly see page 39, annexure N. The principal has not stopped there. He wrote some adverse remarks in his service book with red ink. Dr. Jintu Sharma is released from position of head of the Department of Botany on 28/11/2000 due to few lapses on his part related to important college examination works. And that is why he approached, because he's a brilliant academician with national awards. Now, this type of remarks without, my lord, only basis, without examination or true facts, so that will hamper his career. That is why he's approached. He even wrote a letter to principal, page 42, annexure 5. Say, kindly withdraw these remarks from a service book. This is a 12th May 2023. Secondly, it is also been entered with rating that the undersigned has been released from position of head of the Department Botany due to few lapses in examination work. So I am surprised to send this wrong and absurd statement in the service book. My lord, to confirm that he has not done any damage to students or any lapses, he wrote a RTA application before the controller of examination, whether from the botany department any students suffered or debarred from exam, or any students SEC marks was not uploaded in their portal. So this is the reply, page 42, 2 May 1980. This is replied by controller. This is the application to principal. After that, page 45, kindly see, page 45, I'm sorry. Annexure Q, 29/3/2023. Deputy Controller of Examination. He replied that from their college in the Department of Botany, as referred, it may be noted that there was no lapses in the mark feedings. That means marks was already uploaded, given, and sending against the SEC paper from Department of Botany, Guwahati College in the year 2020. Moreover, no students was suffered and results are declared as per schedule. So he has not done anything. What allegation is unfounded. Now, in our reply, they said that we have not handed over our marks. So we said that portal was not working. Then we approached the examination committee. They refused to receive. After that, somehow we have given it to one Dr. Chawra, who was the one of the member of the examination committee. And to bring on the records, I have filed the additional affidavit, and there I have brought these reports, and they have controversial.
Where's your additional?
It is additional. It is an affidavit by petitioner. Reply to the affidavit in opposition by the petitioner. My lord, I want to. Yes. Kindly, first of all, page 85 annexure, you kindly see my lord. This is the clarification from Deputy Controller of Examination, Guwahati University. Regarding, yes. Page 85, annexure U. Your letter, letter so and so, Dr. Sharma, as referred to, it may be.
That we have gone through earlier.
Yes, yes. Next, that examination committee, that members are given, that is the committee notice, page 86, 5, annexure V, annexure V. This is the committee, and serial number 5 is Dr. Umacharan Chawra. So he was one of the member of this examination committee to whom the HOD has to deposit the marks of the department, and they forwarded to GU. So here, this is the committee, and annexure W, page 87 is the peon book. He has categorically stated that Dr. Umacharan Chawra has received the sessional exam 22, and this is the photocopy of the original, and this is the type copy. Now, this Umakanto Chawra is the respondent number 6. He has submitted a affidavit in opposition, and he is silent whether he has not received any examination. In his affidavit in opposition, he is silent about that, and he said that this decision was taken collectively. Kindly see my affidavit in opposition on behalf of respondent number 6, Dr. Umakanta Chawra. Here, para 5 is relevant from 5-6. Attendance of students' classes for being eligible for appearance in the examination is governed by norms of GU. GU has said that 75% is mandatory. So 75% is admitted that. Para 6, with reference to statement made in I said that petitioner convened a meeting. He also admitted that a collective decision where he was present, that decision was collective decision, not a decision. But he said that we don't know any approval is required because this is a laid down law by norms is laid down by GU. So any approval is required or not, he don't know. But interestingly, he has not made any comments. There's positive statement that he has received the marks.
Where have you stated that you have given the marks to this Chawra?
In reply, I have said.
In the reply?
In a supposed reply.
In your writ petition?
Yes, page 36, annexure K, kindly see. This is reply 2311. C, column C. A, B, and C. Second supposes. Whereas the practical marks of the paper quota SEC, that is the paper in question, has already been received by member of exam committee Dr. UK Chara, dated 17/10/2022. Photograph of the same has been attached herewith. And GU has confirmed that there is no lapses within the time days they have received the marks. But in spite of all this factual, this principal out of some grudge has
Who appears for respondent 6?
Yeah, I mean,
Whether you have received the marks?
Lordship, I have received the mark of my Lordship may mark the date when he has given it to me. That is 17/10/2022. And Lordship may go to annexure 8, page 33 of the petition.
Page?
Page 33, annexure 8.
Yes.
May I read, Lordship? This is the so-called notice. It has come to my notice that as the HOD of the Department of Botany, you have not submitted the internal assessment mark of XCC paper 4th semester student of your department to the College Examination Committee as notified to be submitted on 26/7/2022. That is the gap. He was supposed to submit it in the month of July. And he has submitted in
June. Oh, July. July.
He has submitted me on 17/10 that he has also admitted in his reply. So that is the lab he has committed. After I received the same, I forwarded the same to GU.
Yes.
In my reply, I have categorically said that initially he refused to receive and the portal is not working, so I am helpless. After that, somehow through I have given. But thing is that the students are not suffered, no lapses. It is the clarification of GU control authority. Now, within July or August, whatever may be, this was placed before the GU authority. GU has says that we have nothing to against this Guwahati College Botany Department. Everything is done in time, according to GU. But now they make up a case that instead of July, we have submitted it later. Now, that is not the case. They said that we have not submitted, we debarred. So this is not factually correct. They themselves admitted that this is not factually correct. Now, timing and my explanation that because they initially refused to accept and after that I somehow given. So that is the other matters. But thing is that my SOCOS is issued only 2 allegations that I have not deposited the SEC marks to GU and I debarred some students from appearing examination. This is unfounded. Now they make out a case in July, you have August, September, that is another. But for that, whether without going through this, the principal himself put a stigma in my service book doing something. This made a committee, they should arrange a committee whether and is there is any provision that within that such stipulated time you have to submit. That is to be discussed. But here prima facie, he has given everything. What university has clarified that nothing lapses are within the time and students are also all get their benefit, they enter in the examination. Sessional examination is the in the internal matter of a department and they can regular the unruly students that we will debar you from the appearing if you are not regularly attend this class. For that measures they have taken. Later on, they have arranged a separate exam and allow them to appear and their marks are all same. So what is the wrong on the part of the petitioner HOD? This projected that they have done a lot of against the interest of the students, against the interest of the college and authority. So this is the allegation is unfounded. So without the basis, the stigmatic action is taken against this petitioner, who has otherwise a brilliant career. He received the national award or he has so it is not sustainable. It is not sustainable. Only the gap period is not sustainable. In SOCOS notice, this is not mentioned that instead of July, you have submitted letter on second SOCOS. Now they develop this case.
No. It's your reply that has developed the case.
Yes. We said that initially.
In the show cause notice.
Yes.
This, it is clearly stated notified to be submitted on 26/7
Yes.
2022.
Yes.
All right.
Yes.
And in your reply, you have said that.
I said
you
that there is
such-
no such communication, but I tried by the page 34 annexure I that we tried twice, 29/9/2022 and 39/22, but they refused to receive and portal is not working, so I am helpless. That was the
No,
explanation.
here also it is 29/9/2022 and 39/2022.
Yes.
But you were supposed to submit by 26/7/2022, isn't it?
To that reply, he said that I have no such communication as made that it should be in July. Because end of the year that should be received by the GU. And before that, sessional marks, they can carry out the sessional test like unit test at that time. But before the closing of the year.
See, you are the head of the department.
Yes.
Correct.
Yes.
You are supposed to do certain things in a particular manner, which is specified by the college authorities. So you're directed to submit the marks of the sessional exams.
Yes.
On 26 July 2022.
Yes.
And in your reply, you've said that you tried to upload them on 2 dates.
My lord.
All right.
Yes.
On 29/9/2022 and 39/2022.
Not unsuccessful. After that, he somehow given it, and they also admitted
But that was after 2 months.
maybe.
And then, what do you mean by maybe?
My lord, then my lord, kindly come to the page 30, my lord. This is the notice, my lord. Kindly see.
Page
30, annexure F.
Yes.
All HODs are hereby notified to upload the sessional marks in GU portal on or before July. Then botany is in 26/7/2020 botany. Now, here is the gross mistake on the part of the principal. Sessional marks is never uploaded to GU portal. Sessional marks is the internal unit marks. The marks, internal marks are uploaded to GU. Internal marks comprises portion of sessional marks, percentage, skill development, all this comprises that. So here a wrong instruction is given. So he has rectified. Sir, I have confusion regarding sessional marks filling. I think this will be internal marks, not sessional. So sessional, internal marks, it should be uploaded in GU at the end of this academic year. Sessional marks, he has done a wrong instruction, my lord. Either understanding or not understanding.
See, as British notification,
My lord.
there are different departments.
Yes, botany.
Correct.
Yes.
All the departments have done it except botany.
I don't think so. Mark, that is that they have not submitted, they have not come with this. And my personal knowledge is that is not, I know it is
No action were taken against any of the HODs.
Yes, yes, yes. And
in
here
the different departments.
Yes.
Except botany.
Botany.
So you are the only culprit. You are the only person
Whether
who has not uploaded the sessional marks. You just specifically stated 26/7/2022.
But whether sessional marks are uploaded in GU.
No, give me an explanation.
Yes.
When this notification was provided that you should upload by 26/7/2022.
Yes.
Why did you try on? Why did you try only on 29/9/2022?
Because
and
sessional.
39/2022.
Yes, my lord. My lord, sessional marks cannot be received by the GU portal because this is nothing to do with the sessional marks. Sessional marks within the department to test efficiency.
Okay,
Yes.
who appears for the GU is a party?
GU, and I don't think anyone is appearing.
No, Fukon.
I am appearing for the college author.
Okay.
You know, only the page 45 regarding deputy controller response.
Yeah, that response,
Ultimately, the marks were sent by the principal, my lord. That is also in my affidavit, I have shown, my lord. These marks were ultimately forwarded on 29/11 by the principal. In November, my lord, after we received it from him in October. So there is a lapse, and further, my lord, if my learned friend has concluded, then I can start, my lord.
yeah.
Then, my lord, under the facts of circumstances, my lord, is it a fit case that some disciplinary action, that too, without coming to the, going through the, all the factual, in impugn order, there is nothing mentioned about that you have to get, can be imposed to harm the career of a prospective career of a petitioner. That is the question, my lord. And this is prima facie sectional marks. He has wrongly mentioned it should be sectional mark. Sectional marks cannot be uploaded in July, my lord, because sectional internal marks comprises sessional plus percentage of plus skill, all these things that may not be possible in July, my lord. It will come at September or October, my lord. So here's the wrong instruction is given, and he also clarified that. Now he cannot rely upon this that in 27 sessional marks is uploaded. Sessional marks cannot be uploaded to GU portal. Sessional marks is a one of the component. And end of the academic year, sessional marks plus practical plus internal assessment, all are make 20%, and 80% is the written statement, written exam. And 20 marks is comprises all this. One of the component is sessional. So how can the internal marks can be uploaded in July, my lord? It is always uploaded in the September, October.
No, it's not internal marks, it's the sessional marks.
Sessional means in the department, the professors and HOD taking a test for their upliftment.
So those marks were supposed to be uploaded on 27th of July.
They cannot. Sessional marks cannot uploaded in GU portal or cannot.
Then what about the other departments?
Other department, they have not. He is against this petitioner personally, my lord. That is the question. Otherwise, a committee could be constituted to examine all these facts.
Okay.
My lord, that is not done, my lord. Procedure is not followed. He is the judge of his own cause. He has first so cause reply, second so cause reply, then he take a decision when there is a clarification. So that should be examined by a committee, or he directly come with the impugn orders and even not stop their writing some adverse remarks. So that is without any inquiry. And he says that your reply is not satisfactory, but GU says gone, then it is already perfectly done, no lapses. So the allegation has prima facie no basis. Now timing period, so there should be come with a clear cut that should be sessional marks or sectional marks. That should be within July. There is no such.
You agree only with the entry in your
Yes, my lord.
service book.
Yes, my lord. That is too much, my lord. If we presume that something time, actually it is not, because sessional marks itself is wrong.
You are not agree with this letter 28/11/2022.
I am agree, but by that time I think all right, you taken my HOD, I no problem, but you come to personal grudge to write something in the rating in a service book, it will affect that should be with a serious manner, my lord, with elaborate examinations.
Yes.
But if my learned friend is saying that he is not agree with the taking of his headship, then I'll have a different argument. Because the writ petition basically has two parts. One is the removal from the headship, and there is the judgment of our High Court that this is given as per an office memorandum. Our High Court has held that, my lord, that it does not give a substantive right. You do not get a substantive right, even if you are removed. The under 226, the report will not enter. But so far as the writing in the service book is concerned, my lord, that part is, my lord, lordship may not record, but that was not proper, even if a lordship asks me. If that is interfered with, it is expunged. I don't think I'll have any objection. But lordship will not record that.
No, no, I'm not recording that.
Because that part,
That's why I was asking
that
this,
part.
this court was asking one question. Whether he's agree with this letter of 28/11/2022, page 37.
Because
if you are not aggrieved,
My lord, I am agree to that extent that my removal should not be with stigma.
No, if he is arguing that, my lord, then I
If you
rely on
have,
the judgment.
if you have some discretionary power, you can remove me, but don't put a blame. And that
no,
is
no, okay, come with the specific argument.
Yes.
yeah.
Are you aggrieved with this communication 28/11/2022 or not?
As on now, my lord, it is infructuous because my 3 years headship already expired due to pendency of the seat. So I can again put it not, but my stigma, that should not be with my service book. That will harm me.
Yes.
That part I've already submitted. my lord. That, even if it is expunged, but the headship he will not get back. It will come on rotation, my lord. It is given on rotation on 3 years basis as per a office memorandum. But so far as the writing in the service book with red letter, my lord, that. But otherwise, all these are all disputed questions, my lord. Whether he has given it to the respondent number 6 or not, who has received when.
So on the
Because
disputed
on merits, if I have to argue, my lord, there are other allegations also, even in the show cause notice. He did not allow certain students to appear in the examinations. Then later on, he conducted an internal examination, allowed those students with the same question paper. All these are there. So let us not go into that.
My lord, to answer to, I have also answered this, that when the examination was conducted, he was on leave. So present HOD, he has conducted. And this questionnaire said by writing in the department itself, because it is a inter-department examination. The botany students of this, they should test themselves, whether they are competent to this. So these are examine was held, that 2 days he was absent. He was, so it's Chawra, who was the HOD, he was given, he has conducted everything. Now putting blame of this petitioner who was absent, who was on leave, I have replied in my annexing my absent petition from headquarters leave. So these are the things they can continue. But thing is that, main thing is that the 2 allegations, whether it is founded on true facts or not. And your lordship may ask, yes, there is a delay. Why in July, sessional marks cannot be uploaded. So this is a wrong instruction. For wrong instruction, how can we be blamed?
Hurt, Mr.
MJ Boroman.
MJ Barrow, Learned Counsel for the petition.
I am appearing for 4 and 5, my lord.
Also hurt.
N deca for 4 and 5.
Mr. M. Deca. Oh,
N deca, my lord.
higher education. Mr. S. Buyan, Learned Standing Counsel Higher Education, Affairs for Respondents, 1 and 3. Mr. P.G. Fukan, Learned Standing Counsel, Guwahati University, Affairs for the respond number 2. And Mr. N. Deca.
N deca 4 and 5.
Learned Counsel, Affairs for Respondents,
4 and 5.
4 and 5. And Mr.
S. Chakraborty for
S. Chakrabarti, Learned Counsel, Affairs for the respond number 6. Stop. Para. The petitioner before this court is presently serving as, you are serving as
Now, after headship gone, we are just assistant professor.
As assistant professor.
Botany in Guwahati.
In the Department of Botany in the Guwahati College.
Yeah.
And is aggrieved by the remarks of the principal made in his service book. Where's that service book?
Mother, page 39 is the type copy and
service book, which reads as under with an inverted comma. Dr. Jindu Sharma is released from the position of head of the Department of Botany on 28/11/2022 due to a few lapses on his part related to important college examination works. Close inverted comma. Voilà. Mr. M.G. Barwal and the counsel for the petitioner submits that while the petitioner was serving as head of department in the Botany department under the Guwahati College, comma, the principal of the said college issued a notification. Is it a notification?
So WhatsApp
WhatsApp,
communication, my lord.
WhatsApp notification.
Issued a WhatsApp notification
Communication, yes.
on 25th of July 2022, informing all HODs to upload all the sessional marks in the Guwahati University portal within bracket 2, 4, and 6 semester 2022 and 6 semester all practical and project works on or before 29 July 2022. Third, in respect of the Botany department, the date was fixed as 26/7/2022. Stop. He submits that the petitioner draft tried to upload the sessional
No,
marks.
sessional marks cannot be uploaded. Like, that is my point, my lord. Here it is, he also the question. Sessional marks are internal matters of this college. How can his U portal accept receipt?
Then what is there in your reply?
In reply, it is SEC marks. It is a skill enhancement course. This is quite different from sessional. Skill enhancement course. That was he tried to submit. It is a bearing on these marks, marksheet.
Okay.
SEC marks.
Stop. However, as there was no portal in the as there was no portal under the Guwahati University for uploading the sessional marks, the petitioner sent a message saying that it may not be a sessional mark fitting, but it could be an internal marks. Stop. Draft, a show cause notice dated 21st December 2022 was issued to the petitioner by the principal Guwahati College, wherein it is stated
SEC
that the petitioner has not submitted the internal assessment marks of the, what is it, SEC?
A skill enhancement
Skill
course.
Enhancement course.
Yes.
Within bracket SEC in short.
Course.
Of the 4th semester students of the petitioner's department to the college examination committee as notified to be submitted on 26/7/2022. Stop. Further, the petitioner, it was also alleged that the petitioner has prohibited a few students of the 3rd and 5th semester to appear in the sessional examination, which was held from 13th to 28th October 2022, without informing the college principal. Stop. Accordingly, petitioner was directed to file his reply on or before 27/10/2022. The petitioner accordingly met his reply on 21/10/2022, clarifying his stand and also stating that the examination committee refused to accept the practical mark folio of SEC paper on 29/9/2022 and 39/2022. Stop. Further, comma, the petitioner clarified that with regard to the prohibition of few students from appearing in the sessional exams, the said decision was taken departmentally based on the directives of the respective president of the governing body during its meeting with all the faculty members on 13/8/2022. Stop. Draft. Another show cause notice dated 22/11/2022. No, first show cause was
21/10.
10,
Oh,
21.
it is 21/10, not 21/12.
Okay.
Draft. Another show cause notice dated 22/11/2022 was issued to the petitioner by the principal of the Guwahati College on the same allegations already made in the earlier show cause notice dated 21/10/2022. In his reply to the show cause dated 22/11/2022, the petitioner categorically stated that the practical marks of the paper in that the practical marks of the paper
In question,
dash SEC has already been received by the member of the examination committee within bracket Dr. UK Chawra on 17/10/2022. Stop. Further, as regards the prohibition of few students with from appearing in sessional examination, he clarified the said decision was taken departmentally based on the supports and directives of the respective president of the governing body, as already mentioned in his earlier reply dated 21/10/2022.
and para F in it is mentioned that already.
Stop. Further, he also clarified that he has submitted all the sessional marks to the examination committee in time, including the earlier prohibited students, by organizing a special sessional test after they met the required criteria. Stop. Para. Learned counsel for petitioner submits that despite the clarification made by the petitioner in his reply on 23/11/2022, comma, the principal Guwahati College by a communication dated 28/11/2022 released the petitioner as HOD of Bhutani with immediate effect and directed him to hand over charge to the next senior teacher, Dr. Umakanda Chawra, Assistant Professor, Department of Botany, with effect from 28/11/2022. Stop. Accordingly, the petitioner handed over charge to the said Dr. Umakanda Chaura on 28/11/2022. Stop. It is submitted that the petitioner being a while going through his service book, he came across the remarks made by the principal of the Guwahati College, which and being aggrieved, he made an RTI application, correct?
Yes.
Before the
Geo authority.
Deputy Controller of Examinations,
Yeah.
Guwahati University,
Yes.
who in turn replied on 29/3/2023 that there was no lapse in the marks fitting / sending against SCC paper from the Department of Botany, Guwahati College in the year 2022. And moreover, no students suffered and results were declared as per SEJU. Stop. He therefore submits that as none of the students had suffered and had suffered, and as the petitioner had submitted the marks fitting with regard to the SCC paper in the Botany department, comma, the remarks made in his service book by the principal of the Guwahati College is unfounded, and the same is stigmatic, which would affect his future career. Stop. He therefore submits that the remarks made in the service book of the petitioner be expunged, be expunged by giving a direction to the principal of the Guwahati College. Stop. Para. Mr. N. Dekal and Counsel, appearing on behalf of respondents 4 and 5, on the other hand, submits that as the petitioner had not submitted the SCC marks on time, as already in terms of the WhatsApp notification, comma, the petitioner has been removed from the headship of Botany in the Guwahati College, and thereafter the petitioner, the principal of the Guwahati College, had met the remarks in the set service book of the petitioner. He therefore stopped accordingly, comma. There's no infirmity in the remarks made in the paper book and no in the service book, and no interference should be made. Practically, that's the thing only.
Since Lordship has not gone into the.
I'm not going into other things. I'm just going into the service.
Matter.
Mr. P.G. Foucault, Learned Standing Counsel, Guwahati University, submits that the records of the Guwahati University indicates that the SSC paper with regard to the Botany department in the Guwahati College was submitted on time, and no students had suffered, and the results also were declared as per schedule. Stop. He therefore he accordingly submits that as per the records of the Guwahati University, there was no that's on top. I've said already. So, you want to say something?
I'm the beneficiary of the order. Now I am holding the post of HOD.
Mr. S. Chakravarti, no?
Yes.
Learned Counsel appearing for respondent number 6. On the other hand, submits that the that the that the reply of the petitioner to the show cause notice, that the reply dated 23/11/2022 of the show cause notice dated 22/11/2022 would clearly indicate that the petitioner had submitted the SSC marks to the respondent number 6 only on 17/10/2022, which is much later than the date already specified in the WhatsApp notification issued by the Guwahati, by the principal of the Guwahati College. Stop. Under such circumstances, the petitioner was removed from the headship of the Botany department, and the respondent number 6 is allowed to hold the headship of Botany department till date. Stop. Para. I have considered the submissions forwarded by the learned counsel for the parties. Stop. This court has perused both the notices dated, show cause notices dated 21/10/2022, as well as the show cause notice dated 22/11/2022. A perusal of the same would clearly indicates that the allegation made against the petitioners are identical. Stop. Further, comma, the reply made by the petitioner to the show cause notice has also been considered by this court. Stop. In the said reply, in the reply made by the petitioner on 21/10/2022, it is clearly indicated that the petitioner tried to inform the exam committee. That the petitioner, that the examination committee refused to take the practical mark folio of SSC paper on 29/9/2022 and 30/9/2022. Stop. Continue. Stop. Further, in his reply to the 23/11/2022, this court has noticed that the petitioner has submitted the SSC marks as regards the Botany department to the said Dr. UK Chowra, who was a member of the examination committee on 17/10/2022. Stop. This would clearly indicate that the petitioner had failed to meet the deadline as specified in the WhatsApp notification dated 25/7/2022, issued by the principal of Guwahati College. Stop. However, on a perusal of the reply of the RTA reply made by the Deputy Controller of Examination, Guwahati University, it is seen that there was no lapses in the marks fitting against the SSC paper with regards to the Department of Botany in Guwahati College in the year 2022. And no students had suffered, and results were accordingly declared as procedure. Stop. The independent reply, the reply made by the Deputy Controller of Examinations, Guwahati University, is an independent is a reply by an independent body, and therefore this court has no hesitation to accept the remarks made by the Deputy Controller of Examinations, Guwahati University, made on 29/3/2023 in response to the RTI application made by the petitioner. Stop. Further stop. Para. The insertion of the remarks made by the principal Guwahati University, Guwahati College in the service book of the petitioner has already been quoted here and above. Stop. This court, in view of the reply made by the Deputy Controller of Examinations, Guwahati University, is of the considered opinion that there was no necessity on the part of the principal of Guwahati College to have made such remarks in the service book of the petitioner, which is stigmatic and would have an effect in the future career of the petitioner. Stop. Accordingly, should this court expunge it? Or
Yes, ma'am. That's logical explanation.
accordingly, the remarks made by the Guwahati University,
Now Guwahati College.
by the principal Guwahati College in the service book of the petitioner is accordingly expunged. Stop. I think that
will do, ma'am.
with the above observation, with the above directions, this writ petition is accordingly disposed of.
My lord, one point. My lord.
Yeah.
My lord, in his reply said that I have not received that communication. He has also stated that.
What communication?
That is the 27th sectional mark should be. It is written as sectional. That is why in reply he clarified the page.
See, it was in the WhatsApp.
Yes.
In below that WhatsApp, you made that clarification, isn't that? How
Yes.
can you say you have not received that notification?
Regarding sectional marks, he has not received. Regarding sectional mark, he has received.
So everything is now going on the SCC marks.
SCC marks, on the time he has.
The Guwahati University also has specifically said SCC marks.
Yes.
Nobody is saying anything about
So sectional marks, nothing to do here. So that is, he has not left. That is why I want to submit, and he also take a stand also. In reply, he has said it.
Yeah.
23.
Huh?
My lord, here I seek time because in this case, my lord, they have withdrawn the advertisement which was sold here. The first prayer is accepted. Second prayer is there, my lord, I will amend. I'll get the instruction from my client and amend it. I will give in 10 time. 10 days time, my lord, to amend the petition.
Amend the writ petition.
Yes.
My lord,
You will have to file an application.
Yes, I'll file.
No, my lord, this, the main, my lord, they silence the advertisement. We have withdrawn, my lord, after filing this petition, my lord. So, my lord, lordship may place to produce their prayer, my lord.
Yes.
And they place 18, my lord. They will file separate repetition, my lord, if required, my lord, why this unnecessary pending, my lord. The other repetition, their instructors also, my lord, regarding.
Other repetition doesn't come here. We are dealing with
18, my lord.
1 minute.
the 25/11/2023 originally withdrawn.
Space 18, my lord, A, my lord, certiorari shall not be issued, setting aside and quashing the impugn re-advertisement dated 25/11/2023. And this is withdrawn, my lord. This is withdrawn by this cancel, my lord.
Where's your affidavit?
Yes, my lord. Affidavit is filed on 1/10/2024, my lord. The next is, my lord, page 62, my lord.
Page
62, my lord. Running page, my lord.
This is the fifth time, I wrote 5 times. The fifth time they are doing it one after another.
That is different. We can.
They issue advertisement, I challenge it again, they do it again, I challenge it again. The fourth time.
That is different, my lord. This is new.
But then there's no more course of action.
No, no, the second page is there.
And second, I'm
My lord, let me submit one
I'm
thing.
reading second
Don't,
page,
don't be impatient, please.
my lord, he
It is my petition, my lord. Let me submit. It is my petition. I am the counsel for the
So
petition, my lord.
we are
It is
facing
my,
problem. We are facing
what
problem.
I should do, he should not dictate me.
No, I'm not
I
dictating.
will,
This is very separate,
I will
universal
amend it, bring the facts, including the, my lord, dual advisement.
So see, Shama,
Yeah.
the advertisement impugned at 25/11
Yes.
2023 that
Yes.
has been withdrawn.
Yes.
Now you want a direction. That
No direction.
no,
Just
no,
I'm
you want a
giving-
direction in the event of advertisement. The educational qualification should be upgraded.
Yes. That's what the original.
As per the usual for the post of finance officer.
Yes.
Isn't it? So now there's no more advertisement.
Yes, my lord.
Now they will have to issue a fresh advertisement.
Yes.
If when issuing the fresh advertisement, if that upgrade, that educational upgradation with regards to the finance officer is concerned, is not done,
Yes.
then the course of action will arise. Now there's nothing left.
Yes, my
That is true, my lord.
So
no.
better we close this with petition. And if you agree by any further advertisement, then again you will have to face the court.
No,
Of
but-
course,
but-
I know that you have been coming to court very often.
Very often,
Very often.
poor man, my lord, he out of service, 4 times he is coming to the ground.
But
So
any-
that's why what I wanted, my lord, instead of disposing this, with 2023 preparation, I'll file again new one, it will go to 2024, it will again take time, another year or two. So, my lord, I may allow to amend it, I'll bring the.
No, what type of an amendment do you want?
I will bring in, my lord, the provisions of law that was argued by me. That was argued last time before losses, my lord, that section 20 and section 58. They have to comply with that.
My lord, this is
Well,
advertisement, my lord.
it
This
is
will be
my petition, my lord, I will decide how to do.
No, no, of course, fine. But see, Shama, now the advertisement is gone.
Yes, my lord.
Then
No,
your lordship,
there's
then,
no point in.
no, then your lordship may pass an order, my lord, my humble prayer, that any fresh cause of action,
That is the.
or any for any grievance, he may approach the court immediately.
Mr. R.P. Sharma, learned senior counsel, assisted by Mr.
And
N.N. Nobatia, learned counsel for the petitioner submits that during the pendency of this petition, the respondents have withdrawn the impugned advertisement dated 25/11/2023 by notice dated 23/9/2024 issued by the registrar in charge, Rabindranath Tagore University, Ojai, Assam. Stop. However, submits that the liberty may be given to the petitioner to approach this court if any fresh cause of action arises in the event of any fresh cause of action arises any
Because my second prayer
any
remains, my
fresh
lord.
cause of action arises. Stop.
Second prayer remains, my lord.
Mr. S.K. Medi, learned counsel, appears for the
My lord, I'm for 2, 3, and 4, my lord.
the Rabindranath Tagore University.
Yes,
Isn't it? Appears for the Rabindranath Tagore University. Ojai, stop. With petition is accordingly closed. With liberty as prayed for.
Because they have to comply with the second prayer, my lord.
My lord, will, as per English norms, we will now advertise, my lord, as per English.
1 minute. 772. What is this 6241? This all disposed? Huh? Okay.
In 24 minutes, I have got the instruction. Probably I will have to file an affidavit.
What is this? This also same matter?
No, my lord. This is with regard to the appointment of the grade 4 employees in the Kachar district, my lord.
Okay.
Already
Possible
education
that-
department.
It is, my lord, I have got the written instruction. I'll find out.
B. Burka still under counsel for the petition. Mr. B. Gogoi, understanding counsel finance department, submits that he has received instruction.
Urgency on
And
our
praise
part.
for,
My lord, after 10 days.
praise for 2 weeks time.
A date
File
may be
affidavit.
given, my lord.
Praise the Lord. List on 13th November. Okay.
25.
Yes.
Lordship, firstly, I would like to adjourn the matter for the day as my senior is out of station, Lordship. He has gone for some medical treatment. So kindly the matter may be adjourned for the day and the matter may be fixed after Diwali on any date.
Okay. Is this your instruction?
Yes, Lord. Some report has been submitted. So my lord will keep the thing on record. The DEO has given a report, madam.
Okay.
A copy of the instructions shall be served upon us, Lordship.
My lord, sir, between the court and the thing, my lord, I will
Why don't you keep it? It may get misplaced on the
in
next.
the next date. I'll
On request made on behalf of Mr.
JUNM Laskar.
JUNM,
NM
Laskar on the Counsel for Petitioner. List the matter.
Any date, Lordship.
You want a date?
Yes, Lordship.
13th November.
Much obliged.
26.
Just give him back the.
No, please.
Photo. Das has given the reports or no? I'm not passing a judgment. I see her sitting there still. Okay. Yes.
My lord, this is the matter relates to non-payment of area family pension matter. The regular pension I have received, that is page number 32.
Area pension you want?
Area family pension.
Yes, sir, dear.
Lordship, with regard to this, one communication was made from Director of Pension to the PPG department. So your Lordship, seeking relaxation of this rule 226 and 227 of Assam Service Rule 1969. And thereafter, now what communication that I have received is that again the PPG department has resent back it to the Directorate of Pension, saying that if the arrear amount exceeds 1 lakh, then it cannot be disbursed without a previous sanction of the authority by whom the pension was sanctioned. So with regard to this, I had a communication with them, the officials. So that will Lordship made the matter be fixed next week if your Lordship permits. So that some that clarification which is required that can be sought.
They are repeatedly taking time, my lord. But however,
But I
this, the
admit-
petitioner is this basically challenge person, my lord. How they are saying
Try
for
to
relaxation, my lord.
expedite the matter.
Lordship, just a quick reflection of that. I will communicate and so that in the next day it gets resolved.
Heard Mr. Boro.
But yes, my
Lord, Counsel for the Petition. Mr. B. Deoril and the Government Advocate. Prays for some more time to enable him to receive instructions. Praise the Lord. Please, no. 6th.
So there can be last opportunity for them.
Please,
my lord.
6th November. Okay.
Yes, sir.
We'll see. Let him come with the instruction. Is it sufficient time, 6th? Because I don't have any intention to adjourn the matter next date.
By next Tuesday, they told me. By next Tuesday.
Okay, then I'll list it on 6th.
6.
27.
Obligement.
May please your lordship. My lord, the petitioner is senior so far the graduate teacher is concerned and so far appointment is concerned. And she is also receiving graduate scale earlier than the present respondent, private respondent who is the in charge at the time. Now, lordship kindly see, here they have ignored my claim over the post of headmaster and now file after long long order of the court
that Lordship may kindly see order dated 20/209/23. 209/23. Then they have filed affidavit, and that too by director.
No. Order of this court.
Yes, 209/23.
This is a writ petition of 2024.
24 years.
Then there can't be an order of 2023.
Sorry, 24 years. 209/24.
209.
209/24.
Okay. Okay.
Now, Lordship, you kindly see, here is the law, that is the Assam Secondary Education of Provincialization of Schools, Services 2018. Kindly see page 35. Madam.
Read.
This is the book. This is the book.
Yeah.
Yes. Page 35.
Rules.
Yes, rules.
2018.
18, yes.
Yeah. Which rule?
Rule 14. Proviso. Provided that seniority of the graduate teacher shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher. So this is very clear that their seniority shall be decided on the basis when they receive the graduate scale, who is the senior in receiving the graduate scale. In that view, my lord,
who is that provision which you're reading from?
Rule 14,
Mm.
35, proviso I am reading, proviso.
Mm.
Bottom.
Mm.
Provided that the seniority of the graduate teacher shall be determined from the date of receiving graduate scale of pay by the respective assistant teacher. So both of our assistant teacher. But I have been appointed in the year 1993. In the year 1993, of course, that was in ME school. Science teacher, graduate, and Lordship may would see the page 20. Page 20 may be seen.
Of your writ petition.
Yes, writ petition.
Yeah.
So, the third para may be seen. Now, subject to reversion, Sri Kanailal Das, who is working as assistant teacher, having the requisite qualification of BSc, is hereby allowed to hold the post of science graduate teacher, where Sri P.P. Ghosh is working, and subsequently Sri P.P. Ghosh HS past will hold the post of assistant teacher, where Sri Kanailal Das BSc past is working. Now, consequently, the Sri Kanailal Das is allowed to draw the grade pay of science graduate teacher or rupees so and so plus other allowances as admissible under rules with effect from 1/7/2010. So I have been receiving graduate scale from 1/7/2010. And the private respondent, Raja Chatterjee, my lord, he has been appointed only in the year 2013, my lord. That I have, I could not collect his appointment letter, but I have given statement, copy is served, but he is not coming. So
Is he represented? Is he a party?
He is a party here, my lord, yes.
1 minute.
He is a party.
Notice served.
He is, my lord, respondent number 4, my lord.
Notice complete.
Notice complete. Notice served to all.
Huh?
Notice served to all. And my lord, here the affidavit has been given by the director only. He shows that department is in my favor. So he is even not coming to the honorable court though notice is served. Now, Lordship, kindly see the impugn order, page 17.
Page
17, 17. Subject to page 17, annexure 3. Subject to reversion to his original post without showing any reason thereof, Sri Pradeep Ghosh, BSc with Maths, Assistant Teacher, Bongaigaon Vidyapit ME School is hereby upgraded to the post of Science Graduate Teacher in the same school. Sri Kanalal Das, BSc, who was appointed temporarily, had this order number so and so on dated 30/11/1993. So I am so much senior and receiving the graduate scale from 2010, his annual rules with effect from 7/12/93. Vice Sri Pradeep Das is transferred. Then when my Lord, my genuine demand was ignored, then I filed a petition before the authority member. And authority was pleased that I have a good case on merit. That's why, my Lord, they have forwarded my petition to the higher authority. That Lordship may kindly see page 28. May be said, my Lord. Annexure 7, application for objection of appointment of Sri Raja Chatterjee as headmaster in charge of Bongaigaon Vidyapit High School. With due respect and humble submission, I beg to state that Sri Raja Chatterjee, assistant teacher who joined in the school on 17/9/2013, has been given the charge of headmaster of our school due to retirement of Sri Narayan Kumar Sen, who retired on 29/2024. I joined the same school on 7/12/93. I would like to bring to your notice that Sri Raja Chatterjee has superseded me, the senior most teacher of the school. I have all the required.
Okay, then what happened?
So well, then this letter was forwarded to the director, that page 9 to 29 may be seen. With reference to subject cited above, I have the honor to submit here with the detailed report received from the headmaster Bongaigaon Vidyapit in connection with seniority of Sri Kanalal Das, assistant teacher for favor of.
Where's this report?
Page 29, well.
No. 29 is talking about report.
The report and it is sent to director. After receiving report, and then last part may be seen with seniority of Sri Kanalal Das, assistant teacher for a favor of your kind information, taking necessary action. So, my lord, this letter is written on 5/4/2024, but they are silent over this representation. Now, the director has filed an affidavit. In affidavit, director has said only that it is an stopgap arrangement. As per Honorable Supreme Court's order, one ad hoc employee cannot be replaced by another ad hoc employee. But thing is this, that is not the case. Case is this, when I am more senior and very much senior, not only I have been receiving the graduate scale from the month of July 2010, and he has just appointed in the 2013. So he is receiving graduate scale in 2013. I have been receiving graduate scale from July 2010. So these are the matter of document. They cannot deny this. Now they simply say that one ad hoc employee cannot be replaced. But thing is this, why you have appointed him? What is the reason? What is the reason that you have appointed a person who is much junior to me in respect of qualification also? I am BSc, BT, B.Ed.
When did you receive your graduate scale?
From graduate school, I have received that
1/7/2010.
1/7/2010.
Correct.
Yes.
And then paragraph 6, this private respondent.
Yeah.
received graduate scale from 17/9/2013.
30. This is a matter of record, my lord. So they cannot deny this. They have also not denied this, but only said that one attack employee cannot be replaced by another attack employee. How, why this? Why you have done this? What is your interest? There's a junior person has been appointed, ignoring the genuine claim of the senior person. So you will do illegalities and thereafter you will say that one ad hoc appointee cannot be replaced by another. So first their decision is against law. And moreover, the person who is the ultimate beneficiary, even after receiving notice, he has not come. He has not come. So he is so desperate that department will protect me. That's why I am before your lordship. And that is why, my lord, the other day on 29/24,
1 minute.
it was ordered. The next date it will be, interim order will be passed. That was observation.
So we have filed a affidavit, your lordship. The first point is the lordship to be.
One thing what you're saying
Not-
is that the graduate scale was paid to the petitioner without the approval of the director or the state government. One.
Lordship.
Number two, you are saying that the petitioner has not completed 15 years.
years, yeah.
Rule 14(2)
14 to your lord.
says 10 years, not 15 years.
Lordship to be appointed as a headmaster, to be a
He should have he should have graduate scale of pay
lordship,
and must be serving as a graduate teacher
lordship.
for 10 years,
10 years.
not 15 years.
Lordship, it is
From where has you come with this 15 years?
Lordship, it is an amalgamated school, your lordship.
Maybe,
Lordship.
maybe in amalgamated school, but it's under the secondary rules.
Lordship.
Correct.
Lordship.
2018.
Lordship.
You are covered by the 2018 rules.
Lordship.
18 rules says should have completed 10 years. And you have already stated that the private respondent received the graduate scale of pay quite late after the petitioner. Then it's not a question of replacing an ad hoc by an ad hoc.
Lordship, the regular appointment of headmaster, that is, it's almost over, your lordship. So now
Maybe
there will be
it is over.
Lordship.
But what about the private respondent?
But he is not coming, will
Just
notice.
give him one chance. Can you inform the private respondent?
My lord, may kindly see the order dated 12/8.
No,
24.
that I've already gone through. That the
Notice
notice
is
is complete.
served, yes.
Can you inform the private respondent who is the principal? Principal, isn't it?
If he is the
Headmaster.
headmaster in charge.
Headmaster in charge. The court is passing adverse orders against him. And tell him to appear before the next date fix. Otherwise, he's going to come on either by appeal or review saying that I have not been heard. So obviously, it will be sent on saying here the private respondent. I'll give a week's time. I'll fix a date. On that day, if he does not appear, I'm disposing of this matter. Because he has to come out. Petitioner has to go as in charge headmaster, even for one day.
Yes. Our Chief Justice, one Chief Justice was only for 4 days. Our High Court, my Lord Justice Manish Singh was only 4 days Chief Justice. So law should not be benefited someone in a manner which has no sanction of law. But my lord, I have a.
Para 9, you are trying to divert the attention of this court to something else.
Not sure.
But unfortunately, you have mentioned Rule 14.2.
Not
Rule 14.2 says 10 years, graduate
10
teacher.
years, your lord, 10 years.
You, why are we bringing this 15 years? This is not fair. If you have to do, go according to the rules. Let whoever person is entitled to be the in charge headmaster, let him be the in charge headmaster. But don't do this.
Not
Anyway, I'm giving one chance to the private respondent.
But my lord, kindly keep it as partner.
No, no.
Otherwise, the another judge will say that same thing, I will be in trouble. Already he is enjoying the fruits of promotion being not qualified.
Heard Mr. M.U. Mahmood, learned counsel for the petitioner, as well as M.S. D. Mushari, learned standing counsel.
secondary education.
Secondary education. None appears for the respondent number 4, despite service of notice. However, in the interest of justice, list the matter on 4th November.
Not
4th of November. It is made clear that if the respondent number 4 does not make appearance on the next returnable date, this case shall be proceeded ex parte against him. Stop.
28.
I expected part headman.
No, no. It will not be fair to keep it partnered when the other side is not there.
All right.
On a very short issue, my lord, page 30, lordship, may kindly see. Page 30.
Yes.
By this speaking order, my lord, the petitioner has been transferred from his present place of posting to a school. He was a senior, my lord, accountant in the office of the inspector of schools, Borpeta. Now he has been transferred to the higher secondary school, Borpeta. Now, my lord, before
one
this.
minute. Yes.
Yeah, my lord, before issuing this speaking order, now no notice, my lord, has been served upon. Based on some allegation of some, my lord, third party, I have been directly transferred. And lordship will see this is not a transfer order, it is a speaking order. Not on public interest, but based on some allegation. So only on that instruction, if they can come up that whether any such notice was served upon the petitioner or any opportunity was given to him prior to my lord coming up to this
You
particular.
have joined to
petition.
your transfer.
Then I have joined. Thereafter, I have returned to the man.
Instruction we received, we need some clarification. Although your lordship, that is, instruction has not been served, your lordship. The query that has been made, your lordship, regarding that whether show cause notice has been served upon him or not. So prior to that, your lordship, kindly grant us 3 weeks time to obtain instruction.
Let it be 2 weeks from the director. I will serve a copy also. Let them-
2 weeks.
Only in that one. Also, may I kindly reflect the my lord query
But
specific.
Mr. B. Gogoi, learned counsel for the petitioner, MSP Das, learned standing counsel, Secondary Education Department shall take instructions as to whether the petitioner was issued any show cause notice prior to the issuance of the speaking order dated 5/7/2024. Stop. List the matter after 2 weeks.
So, if you lordship may give a date, my lord, if possible.
Date.
Any
Yes,
date, my-
Das, when you want.
Any date may be given you.
After 2 weeks.
11th.
Obliged.
Deeply obliged.
29. May I please, your lordships? This case is also squarely covered in the order of additional code. Similar case already been disposed of 6/12/2023, that is page 17. I think in this year, this matter may be disposed of, lordship. Petitioner.
In the earlier occasion, there was a dispute saying that the judgment passed by this court is not Does not
That's
cover
not-
the case of the petitioner.
Just to show
That was
which
what
part-
Mr. SMT
My learned-
Chisti argued
learned
the
friend
other day.
Asked my learned friend to show that which part is disputed, is not covered.
Yes,
Change
Sharma.
Otherwise,
Please.
Lordship, as per my instruction, Lordship, the case of the petitioner was not considered because he was underqualified.
That time's over already
He
been.
did not have that qualification, requisite qualification to be appointed as a assistant teacher. That is why his case was not considered. Now, subsequently, the prayer, he is asking for a provincialization because the 2011 Act has already been struck down. Now,
That-
he is asking
actually,
for the
that is not
provincialization
correct.
in terms of the 2017 Act, Lordship. Now,
This case, I am clarifying.
1 minute. Then have you received the instructions?
my instruction is that he is not qualified. So
Then
he
you
has-
file.
Actually, that
you
is
file
not
an
case.
affidavit.
Lordship, I will file affidavit.
That is not actual case. I am clarifying. In 2011, Lordships, my names along with the teacher's name forwarded, since they were eligible institutions and the person eligible, my name's also been published in the website list. Subsequent provincialization against my post, my name has not reflected, showing that post is vacant. Subsequently, I inquired the matter. Director of Elementary Education asked me that since I was not qualified, that HS qualification is required. I apprised him, I already passed, then asked me to submit claim application before the district scrutiny committee. Accordingly, it was submitted, and district scrutiny again forwarded for provincialization. They have not considered. I approached this oral court. This was directed to consider the case on the basis of the subsequent scrutiny committee report. In the meantime, act has been struck down. There is a after struck down of the act, Lordship, in the 2017 act, there is a documents page 54. That is my case, page 54. That is 29th May 2017, Lordship, bottom line, further, the teachers who, Lordship got it, further the teachers whose education institutions have already been provincialized as per the Assam Venture Educational Institutions, province service of the Act to event, but the services have not been provincialized, may submit their application for provincialization of their services under the new Act 17 in the enclosed format as Annexure A for LP school, Annexure B for the. In terms of this, particulars has also been submitted. That is page 57 onwards to page 60. And thereafter, after submission of this, other teachers provincialized in the year 2021, that is on 4/2021. Instead of this, I provided particulars have not been considered. Similar persons earlier approached along with me, exactly similar, also not considered. That case subsequently filed before the court, and that was also disposed of. That's why I am praying for dispose my case similar way.
Yes.
Exactly
Sharma.
similar
Lordship,
case.
let me file affidavit, Lordship. I have the details.
Unnecessary delaying already.
I'll give you 1 week time then.
Lordship.
I'll fix a date.
Lordship.
If you borrow and then a consecutive petition. Urge, huh? On request, Mr. B. N. Sharma, Learned Standing Counsel. Elementary. Education Department submits that he has received instructions and prays for a week's time to file affidavit. Praise the Lord. Released on 6th November. 6th.
30 obliged.
Wait, please, your lordship, my senior Mr. Arindas is not present today. Lordship, kindly adjourn the matter for the day.
Let's provide some instruction, madam. If there is something instruction.
Okay, heard, Mr.
A Bhattacharjee.
A. Bhattacharjee, Learned Counsel for the petition on request made on behalf of Mr. R.M. Das. Learned Standing Counsel, NCLs.
Yes, your lordship.
NCLs. List the matter after?
Next week,
After
after 2 weeks.
Up to 2 weeks.
Date will be fixed, madam.
List the matter on 13.
13. Earlier beginning.
31.
May it please the Lord.
Not this net UG examination, my lord, 50% locomotor.
But the same ballot medical
Same
admission, can it be on Friday, my lord? By tomorrow, I'm filing affidavit.
Third, Mr.
MK Dasker.
Learned counsel for the petitioner on request made by B. Gogoi, Learned Standing Counsel Health Department. List on 25th.
25th. 31, 32, 33, 34, and 56. 31, 32, 33, 34, and 56.
31, my lord, there is interim that may kindly be continued, my lord.
31 interim is there?
My lordship.
What is the?
31.
No. 31, there's no interim.
31 not Asanya? Sadia. My lordship. Interim is there, my lord.
Interim is there?
Yes. In some cases, there is interim.
No. In 31, there's no interim. 31 is the
Guwahati-
PC number?
Guwahati Medical 5158.
5158. There's no.
Guwahati Medical College, my lordship.
No interim order. The interim prayer of the petitioner shall be considered after receipt of such medical examination report of the petitioner by the council.
Then there is another order.
Where?
There is another order, my lord.
Yes, sir.
Sadia Tasmin.
Huh?
There is another order, my lord. Yeah. My lord, order dated 3/10/2024.
3/10/2024.
Just
My
before the
lordship.
vacation.
Till returnable date, one seat for first year MBBS course for the session 2024 shall be kept vacant in Guwahati Medical College, my lordship.
310.
My lordship.
There's no order of
3/10/2024.
310 here. In your writ petition. Oh, okay.
515.
One is here.
It
One
has
is.
not been taken.
It has not been taken. One. Okay, interim order passed early to continue.
Highly obliged, my lord.
I'll wait on that.
I'll say.
Yeah.
Second. My lord, then 5159, my lord. This one, my
So
lord.
same order had MK Das, London Council for Petition on request made by B. Gogoi, London Standing Health Department. List on 25th, interim order passed early to continue.
Deeply obliged. My lord, 5161, my lord. In this matter, my lord, in my case, my lord, there is 40% disability in both eyes, my lord. Then, my lord, on the last occasion on dated 3/10, my lord, a report came, my lord, wherein my disability status, my lord, it came up to be 0% disability. So, my lordship did not allow any interim in my favor, my lord. Thereafter, my lord, the petitioner, because, my lord, in this particular case, I filed an additional affidavit. And my lord, in the morning, I took permission from the honorable court to bring on record, my lord. Then this particular petitioner, my lord, she had, my lord, approached, my lord, because there are 16 numbers of medical colleges which are under NEET UGC, my lord. They are authorized to give certificates for direct admission in all the all India level, my lord, colleges. She had undergone, my lord, medical examination, my lord, and a certificate issued, my lordship. May kindly come to page number 82 of my additional affidavit, my lord.
Yes.
Herein, my lord, her medical examination was done, and my lord, her disability is considered to be for 40%, my lord. So at this stage, my lord, my limited prayer, because anyways, my lord, the department will file their reply. And I have, my lord, annexed this particular document which has been issued.
Instruction on this also, my lord, from our board.
So only limited prayer, my lord, till 25, my lord. One seat, my lord, that
All of a sudden, how?
may kindly be, my lord.
It don't make a difference. It is day after tomorrow.
Yeah.
It don't make a difference.
Because
if something cannot happen on 25th,
my lord,
if something goes wrong, then I'll pass the order.
because, my lord, why I am praying, my lord, this particular girl, my lord, her medical examination was once done, my lord. 40% disability. Department subjected her to medical examination again. 0% visibility, my lord. 0% disability.
Yes.
Now, my lord, this institution, my lord, national level institution, she had done, my lord, and this 40% disability has been allowed, my lord. This particular document, my lord, her disability is 40%, my lord. And that is why, my lord, till next date, because, my lord, one, my lord, the institute, my lord, has already been allotted a seat, my lord, in Nagaon Medical College, my lord. I am praying for that particular seat till, my lord, next date, one seat.
No, that will be difficult. I can't say, my lord, it is still vacant or not. I can't say, my lord, today. On 25th, Lordship will consider, I will be filing affidavit by tomorrow, and by today evening also, I will have some instruction from the authorities about this particular report.
So by that time, my lord, third counseling will also get over. Then, my lord, my chances will,
On
my lord,
25th,
it
my
will
lord, the
go.
third counseling will start.
So that is why third counseling, my lord, on
On
25th.
that day, Lordship will take up, my lord, priority of the particular case. My lord, I will take.
That is why, my
And
lord.
also, I will praise the, my lord, instruction as regards.
But HK.
Till then, my lord, 25th, my lord.
MK does, then Counsel for on request made by B. Gogoi, then the Standing Council Health Department. List on 25th. Prayer for interim shall be considered on the next written.
I will have the, my lord, vacancy status on that.
My lord, otherwise, my lord, if that her allotted seat may be subject to the outcome of the writ petition, my lord, that will also, my lord, give her some protection, my lord.
Make a difference
My
because
lordship.
third counseling is starting on 25th.
25th, my lord.
So we
So
will
that is why, my
we'll-
lord, on
we'll protect-
25th by evening, my lord, this, because today, my lord, this matter has reached on at 4, my lord. By this time, on 25th, if, my lord, the third counseling gets over, my lord.
25th, I'm taking it up on priority, first item.
My lord.
You can mention it, I'll take it up in the first one.
My lord, highly obliged.
And 34?
Deeply obliged, my lord.
34, my lord, same, my lord, on 24th. 25th.
Interim order has been extended.
Okay, heard, Mr.
P. Dolelot.
P. Dollar, then Counsel for additional on request made by B. Gogoi. Then it's Standing Council, Health Department, list on 25th. Interim order first reader to continue till the next written date.
Beg to interrupt, Lord. In this matter, Lordship, the NMC was also implicated, my lord. And we have received written instructions which I have placed on record with the bench, my lord. That may be kept in the file.
No, you keep it with you.
On 25th, I'll place.
Yeah, it may get misplaced.
Yes, my lord. Fine,
You
fine.
keep it with.
But my appeals may be recorded, my lord, please.
Oh, and
With
Mr. D.K. Bhatia, Standing Council, appears for the NMC.
deeply obliged, my lord.
Obliged.
35, my lord, my instructions are awaited. But my petitioner, Paras, my lord, Lordship has allowed the authorities to go ahead with the counseling. 5%, my lord, quota of those students who have, my lord, passed out from government institution.
No, we are
35.
35.
56, same, my lord, on my lord.
Huh?
On 25th.
Who's appearing 56?
56.
My lordship. This, my lord, interim is there, my lord.
Heard MK Das, London Council for the petitioner on request made by B. Gogoi and Zohan. This is an interim order passing.
WPC 5152, my lord.
To continue till the next.
My lordship.
Yes.
35.
My lord, WPC 5162. No interview. Huh?
Alia Hana to it.
WPC 51.
One more thing, my lord. There was one more case, my lord, of my learned friend relating to the same issue. It may come up on my lord on Friday. I will be filing affidavit there.
57, my
There
lord.
is
57.
Item
Item number 57, WPC 5162.
Yes.
No interim, my lord.
On my lord Friday.
Same order.
Same order.
But there will be
But
no
no
entry.
entry.
No entry.
My lord. Deeply obliged.
Yes.
35, my lord, I have my instructions are awaited. Let it be on Friday, my lord. I will have to start. There is no interim there. Though medical admission, my lord, the
Okay.
subject is different.
But Mr. H.M.R. Chowdhury on the council petitioner on request made by B. Gogoi. Then Standing Council Health Department list on 25th.
Obliged.
55 of supplementary list admission.
Lordship may allow some time to file rejoinder. We'll be filing rejoinder to the affidavit filed by department, Lordship.
Your Lordship, here I am praying, Your Lordship, a small prayer, Your Lordship. The affidavit which we filed on dated 11/1/2024 on behalf of Director, Your Lordship, that is respondent number 2. I'd like to take you to page 62, that is paragraph 11. One minor mistake is there, that instead of 1996, that is on paragraph fifth, paragraph 11, page 62 of my affidavit, your lordship, which I have filed, your lordship. Page 62, paragraph 11, fifth line. Fifth, 1/5/1996. Instead of 1/5/1996, it should be 1966, which is the date of birth. So I may allow to correct it. 1996, instead of 99, it should be 6.
You filed an IA. There's no choice. When the petitioners are subjected to all this type of applications, even respondents will have to go through the same. We understand that this may be something typical, but you file an IA, we'll correct it. Okay, Mr.
NZ Chaudhary.
NZ
Chaudhary.
Chaudhary and counsel for the petitioner. Praise for
3 weeks time.
3 weeks time. To file reply to the counter filed by the respondent number 2. Praise allowed.
Another aspect, Lordship, I have a respondent number
After
5.
3 weeks.
Private respondent have not yet filed affidavit.
Sometime will be done. 3 weeks time you file your affidavit.
Of Lordship.
36 of daily orders.
How many cases are there to be? Yeah, no, I have to go once, Radha.
My lord, in this case, in the last 2 occasions, the AD card and the unserved notice has not returned. On respondent number 3 and 4, my lord, I may be allowed to take dusty and the usual AD process.
This is a contempt.
My lord.
And how to take dusty?
Dusty and the usual AD process, my lord. Also, my lord, I have one humble request, my lord, maybe fix immediately after Diwali break, my lord.
Let it come, lordship. I will take care of. I will inform the respondent, lordship. Let it come after Diwali vacation.
Okay.
Yes.
Then, he's undertaking to take care of that.
My lord.
Okay, on request made by Mr.
A.W. Aman.
A.W. Aman, and the counsel for petitioner, list on. When is Diwali? First.
After 2 weeks.
My lord, but this dusty allowed.
11th November.
My lord.
39.
39 also 39. Some they have placed some order.
Well, that order we have withdrawn. That was wrongly issued. Lordship, I have this is the
17 to 24. No?
yes, that was withdrawn, lordship. We have advised the director that it was Then lordship, this particular order was passed in terms of the order passed in the writ petition number in another writ petition number, lordship, filed by one Roman Sharma.
Which order are you talking about?
This is a order. Lordship's order dated annexer, lordship's annexer 2, page 27, lordship may kindly. Para 4, lordship.
1 minute. Page
30.
Of the contempt?
Yes, of the contempt, lordship, page 30. Para 6, lordship may kindly. Similar order was issued, lordship, in terms of the WPC number 3816 of 2021. Lordship is filed by one Roman Sharma and 41 others. So on the basis of the judgment passed in WPC number 38616 of 2021, lordship, this particular order was issued. Now against this order, lordship, we have already filed a writ appeal and it is pending before the division bench. That is the request sent by the director that he has also requested us to file an appeal in this case. And as we have already filed an appeal, so we request this may I pray the honorable court to list it after 4 weeks or lordship?
Any stay order is there?
That information I don't have, Mr. Armado, you are supposed to appear lordship. I think that information I don't have lordship. Whether it was in the-
Unless there's a stay order, then
otherwise,
already that order, that Supreme Court order is there.
yes, lordship.
Definitely. Okay, heard Mr. H. Hetri, learned counsel for the petitioner on request made by Mr. SMD Chishti, learned counsel appearing for the respond number 4. List after 2 weeks.
Yes, lordship.
Observe it.
40.
Yes. Yes, Chaudhary. Is it Chaudhary or Chakravarti? Chakravarti. Union.
Lordship, service is complete,
You're
Lordship. So
interested
one more.
in your mobile only. You're playing games.
40. 40. 40. 40. 40.
Yes, 40, 40, I'm Lordship. 40, Lordship, service is complete, Lordship.
Yeah, that's fine.
Service is complete, but they chooses not to. One more chance may be given on the next date, Lordship may proceed with them.
Heard Mr. B. Chakravarti, learned CGC appearing for the review petition. None appears for the respondent.
One sole respondent.
For the sole respondent. List the matter after 3 weeks. In the admission column.
43.
May it please, my lord. It is a review petition against the order passed by the learned single judge, my lord, regarding challenging the post of president of school SMC, my lord. My lord, I have preferred one IA in the said case, my lord. There's a typographical error, my lord. My lord may kindly have the IA, my lord. Annexure 1, my lord, of the IA, page 11.
Annexure 1 in the IA.
My lord, my lord. My lord, may I kindly point out the error, my lord?
1 minute.
Yes.
Yeah, what is there?
My lord, the school's name should be, my lord, President of School Management Committee of Soraihagi, Hekenamara LP School. My lord, erroneously there is a D. My lord, it should be HEKENAMARA. There is an additional D, my lord. That may be corrected because later on, if the order gets absolute, my lord, or anything, it might be a problem. That is the problem.
No, this review is against this order.
No, no, my lord. This review is against, my lord, the order dated 20 at page 43 of the review petition, my lord. Order dated 29/11/23, my lord. That is separate, my lord. This IA is for the first order, my lord, for correction of the order. My lord. Name of the school has been erroneously reflected.
No, no, no. But in the review, is it correctly shown?
Yes, my lord.
Then
No, my
it's only a notice, isn't it? In the review, it
Yes.
is order.
Yes.
It's only issuing notice, isn't it?
My lord, in the review order is different, my lord. I am the IA that I have preferred, my lord. That is against the order dated 2/2/24 passed by this one.
In the review petition.
Yes, ma'am.
Correct.
Yes.
In the review petition,
Yes.
is the name of the school correctly mentioned?
No, my lord.
Huh?
No.
Where is it?
My lord would kindly have page 11, my lord, of the IA, my lord.
1 minute, 1 minute.
Yes. At page 8 of the IA, my lord, I have given my reasoning also for the same. Error on my part, my lord.
What you are saying is in that order of 2/2/2024.
Yes, my lord.
That extra D has come
Yes,
in.
yes,
isn't
my
it?
lord. Yes,
Have you seen your review petition?
yes, my lord. There also the mistake is there.
Then first you have to correct in the review petition. Only then we can get into 2/2.
Yes, my lord. I may be allowed to do the same. My
Withdraw.
No, no, my lord. I'll do it, my lord, in the form of
Okay, Mr.
Yes, or no, my lord.
Learned counsel for the petitioner. Praise for filing an appropriate application for correction of the cause title in the present review petition. Praise for how much time?
My lord, 2 weeks.
Praise for 2 weeks time to file an appropriate application for correction of the cause title in the present review petition. Praise Allah.
My lord,
List of
there's an interim part passed earlier, my lord. Interim order passed. In the 2/2/24 order, interim has been allowed.
interim order passed earlier to continue till the next.
45.
Deeply obliged, my lord.
In this case, my lord, the notice was served on, my lord, issued on 29/4/2024, my lord. But my lord, the AD card or not, the unserved notice has returned back. So the court, my lord, was held that to consider the matter today, my lord. My summary, your lordship, my lord, the standing council of the executive may take instruction, my lord. Last order 127/9/2024.
This is a contempt matter.
Yes, my lord.
Who are the contemners?
My lord, resolution number 1 is the, my lord, the secretary of the limited education. And my lord, resolution number 2 is the director of the SCERT, State Council of Educational Research and Training.
Yes, you shall check up if these are the correct respondents.
Yes.
One is secretary to the elementary education department and another is SCRT. So.
The names.
Yes.
Are they holding the post?
Yes.
But we are not sure.
We are not about the concern about the Nirada Devi, director of State Council of Education Research and Training, but Narayan Gaur is right.
Then you take first steps.
Narayan Gaur is there.
You take first steps. Mr. D. Kayum and counsel for the petitioner. Press for taking first steps for service of notice on the respondents. Praise the Lord. Petition is directed to take first steps for service of notice on the respondent 1 and 2 by registered post CD within 1 week. Stop list the matter up to 4 weeks.
48.
Made please. In this, I have taken steps, but I don't know. Steps were taken, your lordship.
Yeah.
But neither ready curb nor served notice has been returned. That's it of his note.
Innate. What are respondents?
2 respondents. There is only
Who's the director of elementary education?
Ranjana.
Ranjana Senapati. Then you take first steps. Mr. M.S. Laskar and counsel for the petition. Praise for taking first steps for service of notice and respondent.
Ranjana Senapati and
Praise the Lord.
Petitioner to take steps for service of notice on the respondent 1 and 2 by registered post AD within 1 week. List up to 4 weeks.
49.
Kindly take up the IA 2459 of 24 in this petition. We are just seeking a small, very small amendment in the writ petition. Here, the petitioner is questioning the appointment of the private respondent, this respondent number 4, as principal of the B.Ed college, as he does not belongs to the B.Ed service, but the diet service. Now, the petitioner, it appears, or obviously admittedly, in terms of the rules, he is also not qualified as on date to hold the post of principal. But he's still he's only like prayer is that even if he is not appointed as the IC principal or principal, at least a member of the B.Ed service should be appointed. And the we had in the prayer portion we are seeking a writ of mandamus. Even though the foundational facts are there for seeking a writ of quo warranto, and accordingly, we are seeking to amend the prayer for inclusion of a prayer for writ of issuance of a direction for writ of quo warranto, as well as a submissional lordship prayer. Lordship will kindly peruse page 6 of my IA. Page 6, paragraph.
Quo warranto.
Writ of quo warranto.
Who is the petitioner?
Yes. For amendment of the prayer.
So who is the petitioner?
Petitioner, I am the petitioner.
No, what is the petitioner? Who is the petitioner?
Petitioner, Lordship, he is a claimant for the post, but as on date, he is not yet qualified to hold the post of principal, admittedly. But even though in other colleges, B.Ed colleges.
So you are interested in this post?
Yes, I am interested, no doubt. After 2-3 months, I'll be eligible. There is no doubt about that.
Yes, quo
warranto. Because he, as a citizen, admittedly, the
respondent number 4 here. Lordship, in this case, I am being led by Mr. S. Datta, but apparently he's on legs.
Lordship, since the month of August, we had filed this and a copy was served out, and no objection has been filed.
I understand that, but now he is on legs. I cannot control that. Lordship. He was here all the time. Just 2 more, Mr. S. Datta.
Senior counsel?
Yes. He's in court number 23. I was just
it's
going.
Not he, not Shishir Datta.
No, not Surajit Datta.
Okay.
Lordship, a very small amendment, just a writ of quo warranto.
Yes,
that is.
So, can you pray for a writ of quo warranto?
Yes, Lordship. Yes. Why not? Amendment of the, yes. I can. Only requisite conditions that needs to be fulfilled for issuance of a writ of quo warranto is that the person whom we are questioning regarding, he must be holding a public post. And secondly, he is not, or he or she is not qualified in terms of the statutory rules.
Correct.
Only those 2 conditions. And the entire writ petition contains substantial materials on that point. It shows that he is holding a public post principal. He is holding the post of IC principal of a B.Ed college, provincialized B.Ed college. And secondly, he is not qualified in terms of, in fact, he does not belongs to that particular service, which is essential for holding that particular post.
To pay for some accommodation.
Need that. Friday?
Not
Friday, Lordship.
Friday, he will be out of station. Just
So since the month of August, they have been.
He is here, Lordship.
Yes.
Well, the IA had been filed for seeking amendment. Well, so far as the writ of quo warranto is concerned, my lord, I cannot have any objection. But so far as mandamus is concerned, my IA questioning the maintainability is still there. And mandamus in my respective submission cannot be sought. Subject to that, my lord, the IA may be disposed of.
Lordship, so he has no objection for inclusion of my prayer, amendment of my prayer for inclusion of that writ of quo warranto. That can be allowed.
But not for that I said, my lord, that.
How about the mandamus?
Lordship, that can always, at the time of hearing, that can always be rejected by the honorable court. How can it can be considered at this stage?
Where's the pray for writ of mandamus?
On the IA, my lord, on the IA we have said, because the writ petition was filed seeking mandamus, and that's why we filed a IA saying that this petition is not maintainable at this particular stage.
Because the petitioner himself is not qualified
That can,
to hold the post.
I'll be repeating my submission, that can always be rejected. Mandamus can always be rejected. Just because we are asking for supposing I ask for a writ of prohibition in this lordship, in this writ petition, will that be granted by the honorable court?
Well, so far as the
Lordship will
amended
examine the entire writ petition, the materials on record, and only after that, your lordship, the honorable court will issue the particular writ, whichever is applicable.
In that case, my lord, I'll file a written objection, my lord, to this.
Lordship, since
I
he
thought that
has
my lord-
already submitted that the writ of quo warranto, he has no objection. Only that lordship
No,
inclusion.
no, on mandamus, my lord, because my IA is there. I have
No, no,
questioned the
the
maintain-
writ petition is on the writ of mandamus, isn't it?
Yes.
Lordship, as
Now you're praying for a writ of quo warranto.
no, no, mandamus is there, no doubt. Lordship, we are on inclusion of the prayer of quo warranto. Whichever it is applicable, that will be granted by the honorable court after hearing the writ petition.
You have to come with a specific prayer.
Exactly.
It is whether it's quo warranto or mandamus. You cannot have two prayers. That is settled down. This is
Lordship, there is no such decision
There is
on
a-
the point that
There is a settled law on that.
it is the prerogative of the writ court to issue whichever it is applicable in this matter, whichever it is there.
So you can file both writ.
No, that is
mandamus and quo warranto together.
obviously, Lordship, that was that, as I have already submitted, Lordship. After a certain point of time, supposing the writ petition is not decided within the month of December or January, the petitioner will acquire the requisite eligibility for holding that post. In that case,
That's
in that
fine,
case,
that's fine.
Lordship, what I'm trying
At
to
the
say is
relevant
that
point of time when the petitioner was
No, no.
appointed, this court is going to look into that matter.
what I'm trying to submit is that at that particular point of time, the honorable court may also be of the view that this calls for an issuance of a writ of mandamus. And this can, as I'm already submitting, this can always be rejected at the time of hearing the writ petition or at the time of passing the order. Only what I'm saying is that we are seeking an amendment for inclusion of the writ of quo warranto. That is what I'm seeking.
Well, this submission itself indicates that the prayer of mandamus is not tenable at this point of time today. Because my learned friend's submission is coming that the gentleman will acquire qualification to be considered for promotion only in the month of December or January. So as on date, my lord, he doesn't even possess the requisite qualification to hold the post. So how can he ask for a mandamus?
That we have stated in the writ petition also.
And that is why
we are not suppressing anything.
that is
We are
why,
not
my lord, my
suppressing
IA
anything.
is there. IA 1213 is there. We have said that
We are
the
not
writ petition is
suppressing
not
anything.
maintainable.
Lordship, I'm not suppressing anything. We have stated clearly what is the qualification, what is the standing of the petitioner,
So
what
what
is
do
the
you want to
standing of
do? IA. You
My
want
lord,
to file-
in the IA for amendment, my lord, I will file a written objection.
Lordship,
I'll file a
he
written
has already, it has come from him. It has come from the senior counsel that he has no objection for inclusion of that amendment as regarding.
No,
lordship
I am
quo
my-
warranto.
Provided you withdraw the writ of mandamus.
Yes.
That's what he said.
That is my submission. Two
Yes,
things
Lordship.
cannot go together.
One day, I'll give you a short time, considering that you are apprehensive that the respondent is going to be qualified by the month of December or January.
Lordship, it can be recorded. I'm withdrawing that.
What do you want?
Writ of mandamus. I'm withdrawing that. Let
How
this
can you
amendment-
withdraw in the IA?
Lordship, I can, it's Lordship, it's a writ petition, Lordship. That can be, I'm not pressing for that prayer. I'm not pressing for that prayer. That can be recorded.
Then you want to replace the prayer by this?
Quo warranto.
Quo warranto. Okay. Okay, MSD Buragohin, Learned Counsel for the applicant. Also heard Mr. S. Datta, Learned Senior Counsel. Assisted by Mr.
P. Sengupta.
P.
Sengupta.
Chen Gupta, Learned Counsel, appearing for the opposite party number 4. For the respond number 4. No, as well as elementary. And ACRT. A Fukan Learned
Standing Council Elementary Education for respondent 1 and 2. SCRT anybody? Mr. B. Gogol and Standing Council SCRT for the respond number 3. Stop. Para. By this application, the applicant, who is the petitioner in WBC number 5905 of 2023, is praying for amendment of the said petition as proposed in paragraph 4 of the present application. Stop. Para. MSD Borgohan, learned counsel for the applicant, submits that the applicant oblique petitioner is withdrawing the prayer made in WBC number 5905 of 2023, and she proposes and she submits that the prayer in the writ petition may be substituted as proposed in paragraph 4 of the present.
Except, my lord, subclause 1 and 2, 1 and 3, it is numbered as 1 and 3 in page 7, because these are relatable to mandamus. Page 7 of the IA, your lordship will kindly see. Two prayers have been indicated at serial 1 and Roman 1 and Roman 3. My lord, these are relatable to mandamus.
Lordship, it can be recorded mandamus, we are not pressing.
No, if these prayers are replaced, my lord, in that manner.
Mandamus, we are not pressing. That can be recorded.
Mandamus, you are not pressing.
Yes.
No.
So in these two prayers will also not come.
1 minute.
Why not these two prayers? How can that be?
Now, if these two, no.
These are related to mandamus only.
Lordship, how can that be?
No.
Warrant, my lord, as I understand, my lord, she is questioning my authority to hold the post.
Yes.
That I'll explain how I am holding the post. But that does not give her any right to challenge my appointment. This is a challenge to the appointment.
No, one can be used, but 3.
Yes, 3 cannot come, and in my submission, my lord, 1 will also not come. Because if I succeed in
even 2 will come, because what
here there's a mistake here. In your IA itself, there's a mistake. There's only serial number 1 and 3.
Lordship, it should be 2. It's a typographical error, 1 and 2. It should be 1 and 2. Yes.
So how do we change it now again?
Lordship, typographical error in writ petitions, we always, Lordship, that can be allowed. It's evident, Lordship, it's a typographical
have you
error.
seen the notification issued by this court? Have you seen the notification?
Online filing and all that.
Oh, no, not online filing. Even if there's a typographical error, you'll have to file an IA to change the typographical error. No more you can be permitted to correct it.
Lordship, 1 and 3, that can be read as, it's only numbering, Lordship. It can be read as 1 and 3.
Well, go ahead. Why are you so hard?
Correct.
No, what I'm saying is that it's only a matter of number, Lordship. That can be read as 1 and 3 also.
Otherwise, my lord, as
Why it has to be only
my
1 and 2,
submission is that
Lordship?
she can
What I'm
withdraw
saying
this
is
IA
that-
and file afresh.
I think you should withdraw your IA,
No, Lordship.
file afresh
Lordship, what I'm
by incorporating whatever you want as a writ of quo by specifically specifying in the application that you are withdrawing the prayer of mandamus made in the writ petition, and it may be substituted by the proposed amendment. And then we can allow. Otherwise, this actually there's no mention here in your IA that you're withdrawing the prayer for mandamus.
Lordship, that objection
Only on your prayer. I'm just reporting it.
Lordship, that objection has come now. It was filed way back in the month of August.
So why
Now it has come in the
It's
month
up
of
to you.
November. Otherwise, Lordship, probably technically also this is not a very valid objection, because appropriate writs can be
Okay,
issued by the writ court.
let her come with the prayer and then see. Stop. Para. Mr. S. Data, let us send you counsel. As well as the letter for the respond number 4. And Mr. A. Fukan, Learned Standing Council Secondary Education, as well as B. Gogoi, Learned Standing Council SCRT has no objections. Stop. Accordingly, the prayer for amendment is allowed. strictly in terms of the proposal made at para 4 of the present application. Stop. Para. Next para. In the writ petition, in view of the order passed today in ISO and so, the petitioner is permitted to withdraw the prayer of mandamus in the present writ petition and file an amended writ petition as directed in the IA number so and so. Stop. Let such amended petition be filed within a period of
Within the period of 7 days.
within a period of 1 week from today.
But
Lordship,
if your
strictly-
lordship will kindly observe about the Roman 3, prayer in Roman 3, that is not compatible.
No, no,
Over
that-
and two. One is there, my lord.
Anyway, that you can file your objection.
Lordship, in terms of paragraph 3 and 4, not only 3, because there is a prayer.
What
for
is there in para 3?
para
Actually,
3 for inclusion
your
of a,
proposal is only in para 4.
for that amendment of that prayer in paragraph 4. So far as paragraph 3, inclusion of a small paragraph, a submission.
Okay, okay. Okay, on top say 3 and 4.
Published.
Everywhere, 3 and 4. 3 and 4. Oh, it's time.
May I please, Lordship. Lordship, in item number 60, my lord, there is an interim order. It may be continued.
Okay, due to paucity of time, this case cannot be taken up today. List after 1 week. Interim order possibility to continue.
My lord, I have a request. My lord, my lord, include some pages which are not readable. Page 83 to 85, and there are a lot of pages my learned friend can supply as a legible one.
I can do.
How about the court's copy?
My lord, I am appearing for respondent number 11 in this.
Pages?
Pages 83 to 85.
In the writ petition.
In the writ petition, my lord. I do not know how the registry has passed it.
'83.
My lord.
Totally blind against it. Lord.
83 to
85, my lord.
And
okay, then you cancel the order. The Mr.
H.K. Sharma.
H.K. Sharma, learned counsel for the petitioner, shall furnish type copies of page number 83, 84, and 85.
there are some other pages.
Then 120 to 123.
Comma 120 to 123.
Then 125.
And 125.
127 to 134.
127 to 134. In the present writ petition. To the learned counsel appearing for the respondent number.
Respondent number 7 and 6 and 7.
Respondent
And I'm
6
for
and 7.
11 year old.
6 and 7, as well as to the respond number, to the council for the respond number 11.
But in regard to respondent number 8, 9, and 10, I don't think they are necessary party, my lord.
Okay, we'll consider on the next
Melody.
at least after 1 week. Interim order pass earlier to continue.
Published.
My lord.
My lord, in item number 50, my lord, I have filed an IA, my lord, for continuation of the interim order, my lord. Here, my lord, a notice was issued, my lord, earlier. Then there was a direction to list the matter after 4 weeks. Then, my lord, matter, my lord, did not, my lord, list, my lord. So, my lord, lapse of time is there, my lord. So, I have filed this IA for continuation of the interim order, my lord. So, this IA, my lord, 3019, my lord.
Where is it?
That is item number 50, my lord.
Oh.
IA 3019.
Oh.
That is only to continuation, my lord, the interim order passed by your
That have to
lordship.
consider.
Yes, my lord.
I filed one application for vacation of the stay order.
Oh.
That case number is IA number 3209 of 24. That is not in the record. That may be taken up together.
Okay, list this matter along with IA number
3209.
3209 of 2024. After, along with, after 1 week,
Yes, sir.
after 1 week.
My lord, there is an interim order in the writ petition, my lord. In
That
this-
has not been extended earlier, isn't it?
Yes, yes.
How do you want it extended
Yeah,
now?
in fact, matter did not, my lord, list, my lord. That's the
Hmm.
reason, my lord.
Okay.